Mr. Sage was released.
Oh,
That the court officer went there and there's no Mr. Sage, right?
Correct.
Okay, so do we have another person in custody today or no?
We don't have to.
Okay, so we have one other in custody, but we don't have paperwork. Is that Berkeley?
I hope you enjoyed your walk.
He's not there, right?
no, yeah, he's gone.
He's gone. Okay, but I think Berkeley has someone, right? We understand that Berkeley has someone, but we don't have paperwork. So
Okay.
we're sorry to have bothered you.
Never a bother. I'll be
Today is,
here.
if you see Judge Meineke, today is his 50th. So
Yeah, I know.
the big 5-0.
Big 5-0, scary.
I remember it well,
Yeah.
like it was yesterday. All right. So if we need you, we'll give you a call.
You got it. Thank you, Judge.
So sorry about that. Everybody,
Hello.
my name is Jill Banky. I'm the magistrate assigned to your case today. Is Joyce Oliver here?
Yes, ma'am.
Okay, let me call your case. Calling the case SP 4532789. This is tell me your name, please.
Joyce Oliver.
Okay, Miss Oliver, this was the date and time set for your hearing, and the trooper Papa is out sick and had to unexpectedly go to the doctor. And therefore, we're going to have to reset this because he's unavailable. We
Okay.
will reset the hearing and send you a new notice, okay?
Okay, thank you.
Okay.
So I can log off now?
Yes, you can. Thank you,
Oh.
ma'am.
Thank you. Bye-bye.
Okay, do you see how I know this? That the defendant appeared, officer called sick, please reset. Do I have to write on here like advise defendant? I just
yeah.
put that. All right. Who else has Papa on here?
That Tony at the bottom. Tony,
Is Tony Robert you on bond here? Tony. We'll name Casabon too. Who's Drew Wilson? Who's Motorola Edge 2023?
That's me. I'm sorry. This is Don Schneider you have me as. I don't know what I did.
No, I have you as Motorola Edge 2023. Who are you?
I am, you have me, your court records, Donald P. Schneider.
Okay, for an informal hearing?
Yes.
Okay,
I was given a ticket for no registration. It was like 4 days out of date. I did have insurance.
okay, wait, we're not gonna get into that because I haven't called the case yet, but
Okay, I'm sorry.
do you go by a different name or is that your legal name?
Yes, I'm in the process of changing my name to Vivian Anderson.
Okay,
Schneider.
so I'm gonna identify you and then I'm gonna put is that your preferred name?
Yes, thank you.
Okay, so you're gonna have to help me with that. So let me just identify, is this a Papa case? No. Informal 1001 Schneider.
Mhm.
Okay. Okay, tell me your preferred name, please.
Vivian, Vivian.
Okay.
Anderson Schneider. Yeah, Anderson Schneider with 2 S's.
What are the 2 S's?
Andersson.
Oh, Anderson, S-S-O-N. Okay.
Andersson, yeah.
And you
Family.
have not yet legally changed your name, though.
I have legally changed my name with the courts and the Social Security Department, but I haven't gotten into the motor vehicles yet. That's scheduled for Tuesday.
Vivian, can I just put Schneider because it doesn't all fit?
That's fine. That's fine.
You're keeping that last name?
Yes, so that I can be found.
Okay. And then are your preferred pronouns she, her?
That's fine. I'm not
Okay.
it's not a big deal.
Okay. All right. You are going to be number 2 with when Trooper Gra is here. And then where's Mr. Corey?
That would be me.
I got you.
Yep.
You'll be number 3 when that trooper comes on. Is there a Tony? Who is on this Zoom as the 248-720-878? Can you unmute yourself? Is that who we got before?
That's on the case, right?
Hello?
Are you Tony?
No, I'm Drew Wilson.
Okay, Drew Wilson. Drew Wilson. I keep saying your name too. I don't have you on my docket. On what matter are you appearing, sir? This is Tony.
Speeding.
Speeding. Drew Wilson. Do you have a ticket number or look at your complaint
Yeah, one second.
closely? Tony, are you also on the Zoom with a phone number?
What's that?
Are you a phone number
Uh,
on here?
I'm on my computer.
Hold on. Do you have a phone number 248-720-08798?
No.
Okay. So I know who that is. That could be an arraignment. I don't know. Okay, Drew Wilson. Look at your notice. Is it for today? Because I don't have a Wilson on my docket. Andrew, maybe?
Mr. Wilson careless driving. It says 7:25 at 10:01 a.m. with Judge Fleischer.
Okay, Drew, what's the name?
Hello?
Okay, Drew Wilson, according
Yes.
to my Madam Clerk, you have a pretrial. You have something with Judge Meineke at what time?
Pre-trial, 10:01 a.m.
You're in the wrong Zoom. Do you have, I'm going to give you the right number.
Okay.
Are you ready, sir?
Yes.
Is it Meineke? Okay, it's 305
305
516
516.
0819. You're going to have to start your video in front of the judge. So make sure you can and are presentable, please.
Okay, thank you.
Okay, good luck to you. I have Mr. Tony.
Yes.
Okay, I'm going to rename you. Maybe I should start my speech. Julian Jabber. Okay,
I can speak with Julian.
1 second, please.
He's set at
I
10
see
o'clock.
that. Right, I'm just checking everyone in, please. Maybe I could give them the person on the Zoom, 1-248-720-8798. I don't know who you are, so I cannot check you in. If you have a matter before the magistrate set for today, I don't know who you are, so I can't check you in. This is Magistrate Banky's Zoom. If you have a hearing in the 44th District Court with the trial judge, Judge K or Judge Meineke, you're in the wrong place. But if I don't know who you are, I cannot check you in. Nancy, do you think it would be a good idea if I started giving them their rights? Because I have one Papa case. Tony.
Yes.
Okay, I'm going to call your case, please. Calling the case of SP 454-6901, SP 454-6901A. Your appearance, please. That
Sir.
means tell me your name, sir.
Oh, Tony Unbehan.
Okay, Tony, I'm sorry, sir. Tony what?
Unbehan.
Unbehan. Okay, this is the date and time set for your informal hearing with Trooper Papa. He has called the court and he had an unexpected medical thing come up and he had to go to the doctor. He's not feeling well. Therefore, we have to reset this for a different day because the trooper had a medical issue. So thank you for appearing today. I'm going to note that you were here. You're going to get a new notice to appear for a different date when Trooper Papa is available. Okay.
Okay.
So you can leave the Zoom.
All right. Thank you.
Okay. Thanks. Maybe I should start giving the spiel. And then Patrick will come on. Okay, good morning, everybody. I'm Jill Banky. I'm waiting for Trooper Gra. I don't know who that is. I don't know if I've ever met him or her on my Zoom. But while we're waiting, I'm going to tell you all of your rights and remedies for when the case gets called. You have a number after your name, and that is the order in which your cases will be called. So please, I'm going to explain everything. So when the trooper gets here and I can call the case, we can save time. All the defendant drivers appearing today have a choice. You can, 1, admit responsibility, 2, admit responsibility with explanation, 3, deny responsibility. If you admit responsibility, then it goes to me to immediately assess fines and costs. No one picks that in informal hearings, but that's your choice if you want to do that. The second one is you admit responsibility with explanation. That's where you are saying, I did what the traffic ticket says I did, but here's why. Okay, so you have to admit and take responsibility for what you did. And the explanation, you should address what was going on that day that caused you to meet the trooper on the side of the road, how you treated the trooper during the stop, what you've learned from this experience, and any changes you may have made to your driving. The trooper, upon hearing the explanation, may, but is not required to make a motion to amend the ticket to something less. That could be less fines and costs or less points. Okay? That is the choice that you usually select if you're just looking for grace or break or consideration. The only person on the Zoom that can do that for you is the trooper. I cannot. All right? Any points are between you and the Secretary of State. I can't say I find you responsible, but I can't send a note to the Secretary of State and say there's no fines, or I'm sorry, there's no points. Okay? If you admit responsibility or admit responsibility with explanation, you do not have a right of an appeal. If you have buyers, so know that if you admit responsibility or admit responsibility with explanation, if the trooper doesn't make a motion, you will leave the hearing with the ticket as written. And your admission of responsibility is binding upon you. At the end of that hearing, if you have buyer's remorse, you may file a motion to set aside your party admission. There's no guarantee that the motion will be granted, and you will have to post a bond. The third choice is you deny responsibility. That's where you're saying to the court, I didn't do what the ticket says I did. Okay? At that point, I swear in the trooper and you. I take testimony and evidence from the trooper. I take testimony and evidence from you, and then we end with the trooper. In that hearing, the trooper has the burden of proof. If I find that he has proved just a little bit more, we say 51%, that you did what the traffic ticket says you did, then I have to find you responsible. Okay, so if you choose to go forward with an I deny responsibility and we have an informal hearing, that is an all or nothing proposition. Okay, you will either leave that ticket, you will leave that hearing with the ticket exactly as written, or you will leave with no ticket. Okay, so at the end of that informal hearing, that's it. You can't find out the result and then ask for a motion, for consideration or something less. At the end of the informal hearing, if either side is dissatisfied with my decision, you can file an appeal and have a new hearing with the trial judge. By proceeding today, you give up your right to be represented by an attorney. Each and every one of you is representing yourself. You give up your right to have this matter heard by a trial judge. I'm just a magistrate and or a jury. Okay? So when I call your case,
I'm in court.
you're going to have to make the choice. So I'm going to call your case. I'm going to say, state your legal name. The trooper will give their name. Then the defendant driver gives his or her name. And then I'll say, what is your choice? We don't proceed until you select an option. If you have more than one ticket that's up for hearing today, you can make a choice on each ticket. In other words, you can pick a different one for each ticket. You're not stuck with all or nothing. You can make the choice for each ticket. If you're before the court on expired plates or no proof of insurance or registration, if you've taken corrective action, please have that paperwork available. Okay? We're just waiting for the trooper to come on, and when he or she does, I will call the case in the order of the number after your name.
I'm waiting to be called.
We are on the record this morning now for the 28th Circuit Court here in Westford County. We begin today's docket call by taking up the case of People in the State of Michigan versus Amber Knoll. This is case number 24-13951-FC. Appearances beginning with prosecution.
Good morning, Your Honor. Michael Doby for the people.
Thank you.
Robert Hartel for Ms. Knoll, who joins me to my left, Your Honor.
Thank you. All right, folks, we're here today for yet another final pretrial conference in this case. I know we've gone around a couple times with this case. Last time we were here, the parties talked about entering a plea. The court raised some concerns. I will say away from the record, away from the courtroom, there was some other discussion. The court raised a question about delivery. Was there actual evidence of a delivery? Could this have been considered a delivery? We had some discussions without discussing what we all think the law might say. It seems like throughout those discussions, the parties have reached an alternative pretrial agreement. I met briefly in chambers with counsel, and Mr. Hartel informed me what the pretrial agreement would be, but I'm going to now turn it over to the Assistant Attorney General. Sir.
Thank you, Your Honor. The defendant will plead no contest to count 1, concealing the death of an individual, and an added count 4, controlled substance possession, possession of a controlled substance or controlled substance analog, as well as admit to being a habitual offender, 3rd offense.
All right.
The people will recommend a sentence within the guidelines, which we believe are 10 to 34 months to 10 years.
All right, thank you. Mr. Hartel, is that a complete and accurate statement of the pretrial agreement as you understand it, sir?
It is, Your Honor. I also did regroup with my client after we talked about the fact that the court might feel comfortable with a factual basis to the analogs portion.
Yes. In chambers, I mentioned to Mr. Hartel that I think the court can take the no contest plea as to count 1 underneath the concept of civil liability. Now, it's the charge is concealing the death of an individual, but I don't know where the liability would be, and there's no liability or admissions that would support the actual death, but potentially an intentional affliction, emotional stress, how long it took him or the family to recover the decedent. So therefore, I think it's appropriate. All right. Mr. Adobe, I believe the court then can accept the People's Exhibit number 1, which was previously marked back on April 21st, and that People's Exhibit number 1 was the preliminary examination. Is that what you wish for me to consider?
Yes, Your Honor.
You, Mr. Hartel, will there be any objection?
No objection, Your Honor.
All right, thank you. I'll accept that in just a moment, but I'm going to have Madam Clerk go ahead and prepare another sticker for that. Thank you. I placed that on the transcript, which is contained here in the file. Ms. Knopf, is that how you wish to resolve this case today? All right, thank you. All right, Ms. Knopf, please. I know we've done this in the past. Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth? Yes. You may lower your hand. All right, Ms. Knopf, I know we've gone through some of this before. I hope that you understand here. The interest here of the court has always been to make sure we get justice, and I think we're on our final approach to doing that today. So everything you're going to tell me today has to be the truth. I know I've asked this in the past, but I just want to confirm. Back on November 17th of 2023, were you on parole, probation, or bond? And what was that bond for? First, so in other words, it was not a felony. All right, make sure you speak up because Nancy in front can't hear you. And when her head goes left to right, that means she can't do her job. Okay, so we've talked about this in the past, and you are charged on what's labeled as a second amended felony information, which was filed back on April 24th of 2025. That was filed after there was the attempt to enter a plea and resolve this case on April 21st. And of course, with the sentencing that I issued, you withdrew the plea. But anyways, it reads count 1, charges concealing the death of an individual. That's a felony punishable by up to 5 years and or up to $5,000. Plus, there could be consecutive sentence within the discretion of the court for any other conviction arising out of the same transaction. Mr. Dovey, are the people intending to request, or are they agreeing to not request consecutive sentencing since the other count still, I guess, involves the same transaction?
We are not requesting consecutive sentencing.
The court therefore will understand that this, there will be an agreement that Killebrew has to the current treatment. That makes sense, Mr. Hartel?
It does, Your Honor. Thank you.
All right. Ms. Nault, that's better for you. All right. So I'm told today you're going to enter a plea of no contest. And a plea of no contest, it has the same impact as a guilty plea. The difference is instead of requiring you to recite a factual basis, I'm going to take a look at another exhibit, which I did before, and I will again today, which I've read it several times, so I know what it says. Now, you're also going to be pleading as a third habitual felony offender. That has the ability of increasing that maximum punishment within the discretion of the court from up to 5 years to up to 10 years, and from up to $5,000 to up to $10,000. Count 2 is a charge of delivering of a controlled substance causing death. Now, that is a felony punishable by up to life and or any term of years. We've talked about that in the past. Oh, wait. I see that the felony information has a second habitual felony enhancement.
That was the first plea that was entered.
Yeah. Oh, okay. Based upon the, okay, hold on. That's why I'm wrong. Let me keep going backwards here in the file. There's the original amended felony information. Boom. So I'm going to go back. That's all. That first offense, concealing the death of an individual punishable by up to 5 years, could have been punishable by up to life if you were sentenced as a fourth habitual offender, but because you're pleading as a third habitual felony offender, the maximum punishment is increased up to 10 years. Do you understand? Now, count 2 is a delivery causing death. That's a felony punishable by up to life in any term of years. And technically, there's a fourth habitual felony enhancement that could affect the minimum guideline scoring for that type of offense. However, count 2 will be dismissed. Count 3 is a charge of larceny less than $200. That is a misdemeanor punishable by up to 93 days and or up to $500 or 3 times the value of the property stolen. That count will be dismissed. Now I'm told that you're going to plead to an added count 4. The added count 4 would be for possession of a controlled substance analog. Analog just means it's a form or basis of or based upon another controlled substance, typically a prescription medication. Now that is going to be punishable by up to 2 years and or up to $2,000. And as a third habitual felony offender, it could be increased within the discretion of the court of up to 4 years and $4,000. You understand? Now, again, there's an agreement that these 2 sentences for these 2 offenses will run concurrently at the same time. In other words, if I give you a year for each, you'd only serve a year. That's what concurrent means. Do you understand? Do you have any questions about what I talked about thus far? All right. Now, by entering a plea of guilty or no contest, I'm sorry, by the way, I'm told you're going to plead guilty to the possession of the drug. By pleading guilty to count 4 and no contest to count 1, you're not going to have a trial of any kind. You'll be given up certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to try without a jury if you chose, and court and prosecutor consented. the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify if you chose to testify. Do you understand those rights? And again, you understand that if you plead no contest and or guilty, you will be forever waiving those rights as they apply to this case. Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal and not a claim of appeal by right, which is only allowed when you're convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. All right, next is the plea of your own free choice. Now, there's one more term or condition about on this case, and it has to do with sentencing. People have agreed, not necessarily as a Killigrew agreement. Killigrew means that if I don't go along with it, you have the right to withdraw your plea. But they agree that they are going to recommend that you be sentenced within the guideline range that they and your counsel have estimated. First, I highlight for you that it is an estimate. Now, considering we've had this case before the court and we've already seen a scoring, we pretty much have a strong idea of how it's going to score, but it is just an estimate. You understand? And again, it's not a promise. You understand that? Also highlight for you that the Michigan sentencing guidelines are not mandatory upon courts. They are valuable tools to be used by the court to establish a reasonable proportionate sentence, but it's still left up within the discretion of the court. Do you understand? Okay, make sure you speak it up, Ms. Null. And so that recommendation is, that estimated guideline again was that the minimum would be set somewhere between 10 months and up to 34 months. Okay. You still wish to enter the pleas as we discussed? As to count one, this is the one that I anticipate the plea to be no contest. Hold on, let's see what Mr. Potter's saying to counsel. Mr. Potter's a probation officer. Any issue there, Mr. Hartel?
No, Your Honor, I was just sidebars about potentially the PSI later. I apologize.
No problem. I just wanted to make sure before I took the plea, I didn't have anything messing it up. All right, Ms. Knopf, as to count one, how do you plead? And as to added count 4, the possession of analog, how do you plead in that one? All right, and before I can accept that plea, I need to have you tell me what it is that you did that makes you guilty of that added count 4 first. Hold on. Turning your attention back to November 17th of 2023 in Cherry Grove Township here in Wexford County. Did you possess a controlled substance?
Sure.
And what was the controlled substance that you possessed? Fentanyl. And did you have, in your opinion, any lawful rights as a prescription to have that fentanyl, no matter how long you had it in your possession? And did you know that's what it was? All right. The court believes that based upon it being that the charge of an analog being lesser included, that's an appropriate description of facts. Do you agree, Mr. Hertel?
I do.
Do you agree, Mr. Dobie?
Yes.
All right, thank you. Now, in the admission for considering count 1, the people have offered to present to the court People's Exhibit number 1 that I've talked about in the past. Mr. Hartel, does the defense again stipulate for the consideration and admission of that exhibit?
We do, Your Honor.
People's Exhibit number 1 is hereby admitted. Again, I'll highlight that I have reviewed that several times prior to taking the bench today and throughout the processing of this case. Mr. Hartel, do you believe that the interests of justice do not require to recite a factual basis for potential civil liability?
I would agree, Your Honor.
Mr. Dobie, do you agree?
Yes.
And Mr. Hartel, do you believe it provides a factual basis to support a plea as to count 1?
I do.
Mr. Dobie, do you agree?
I do, Your Honor.
Mr. Hartel, as to both counts in the entirety of the plea, are you aware of any other promises, threats, or inducements?
I am not.
Mr. Dobie, how about you, sir?
No, Your Honor.
And Mr. Hartel, do you believe the court is in compliance with Mission Court Rule 6.302?
I do.
And how about you, Mr. Doe?
Yes, Your Honor.
Also, Ms. Knopf, is it true that, please make sure you pay attention, Mr. Dobie, so you can file the amended complaint as follows, or amended information. Is it true that back on February 17th of 2009, in this court, you were convicted of attempted larceny in a building? Is it also true that a part of that same case, on that same date, in this same courtroom, you were also convicted of attempted financial transaction device, illegal sale or use? All right. The court finds that the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds that for count one, the interests of justice do not require the defendant to recite a factual basis. I'll also note that in the past, there has been support from the, or at least it's been reported to the court, there was support from the victim's family, at least as to that count. The court finds that the factual basis contained in People's Exhibit Number 1 supports a conviction, and therefore the defendant is found guilty of count one. As to count four, possession of an analog, again, the court finds the defendant's plea is made freely, knowingly, and voluntarily. And the court further finds that the testimony provided by the defendant under oath on the record will satisfy the elements of that offense. Therefore, she is found guilty of count four. Furthermore, the court finds that there has been a demonstration that she qualifies, that there is a qualified sentencing enhancement to a habitual offender third, based upon her admissions to the two prior felonies on February 17th of 2009 in this court. Therefore, she's found guilty of count one, add count four, and the habitual offender third. The remaining counts will be dismissed and the enhancements at the time of this. Ms. Knopf, this should be pretty quick and easier because you've already prepared and done all the pre-sentence investigation report. Do you understand?
Yeah.
Any questions about what we have done today? No. Mr. Hartel, anything further?
No, Your Honor, thank you.
Mr. Dobie, anything further?
No, thank you, Your Honor.
Mr. Hartel, can you remind me how much time has she been in pre-trial?
I know not all of it counts, Your Honor, but
Because she had a prior, she was serving a sentence at one time. Is that
she
right?
was.
All right. Do you remember how much?
She advised me January 30 was the completion of her sentence, Your Honor.
All right. So in this particular file now, she's got about getting close to 8 months, 7 or 8 months, correct?
Yes, Your Honor.
Okay. All right. The court continues to withdraw or revoke bond, remand in custody of the Wexford County Jail. Ms. Knopf, keep in mind that for every 30 days that you've served, you in effect, your conduct time counts as well. So anyways, that'll go a long ways. All right. Thank you all very much for your time. We are adjourned.
Thank you.
Thank you, Mr. Dobie. You're free to go. I'm going to take care of Amber Morton next, just to get her out of here. And her counsel. Okay, thank you. All right, we're going to take next the case of People of the State of Michigan versus Amanda Morton. This is file 25-14075 FH. Appearances, please.
Good morning, Your Honor. I'm David Marvin here on behalf of the defendant.
All right, we are here today for a final pre-trial conference. We did conduct that in chambers between myself and counsel. Regrettably, we could not go much further because Ms. Morton has elected to not be here. Through counsel, I've been informed that Ms. Morton knew about today. She even communicated with the defense counsel's office, even as much close as within the last week, I believe. And she has elected not to be here. The court finds that to be a willful and deliberate choice. Therefore, the court will issue a bench warrant for the arrest of Ms. Morton. This case is currently set for a trial. That trial date should be in about 10 days. Let me make sure I've got the date right. Does anybody else know the date?
August 12th.
August 12th. It will remain currently on that trial docket. However, if we get to that day and she isn't here, then we'll have to adjourn the trial, or maybe if she gets arrested, maybe we'll resolve the case short of trial, but we'll just wait to see what's going on. Anything further today, Ms. Carey, on behalf of the people?
No, thank you.
And Mr. Marvin, anything else? Nothing. Thank you very much. We are adjourned.
Thank you.
Thank you. Our next case this morning is people. I'm going to take care of Mr. Beebe's file because we have an attorney general waiting for us on Zoom. So we're going to take next the case of People of the State of Michigan versus Ryan Beebe. This is file number 25-14008 FC. Appearances from counsel, please.
Robert Hartzell from Mr. Beebe to join us as well.
All right, now also join us via Zoom is an special or assistant attorney general, whatever they call her, Melanie Smith. Ms. Smith, are you able to see and hear us today?
I am, Your Honor. Thank you.
All right, thank you very much. We are here today for a final pre-trial conference on this case. This case is currently set for trial also on August 24th. I met with Mr. Hart. 12. I don't know why I said 24. Thank you very much. Because it's the same numbers, anyways. August 12th. All right, so Mr. Hartel and I spoke briefly in chambers. While I know technically that was an ex parte communication, was only to tell me what he expected to happen today. Mr. Hartel, can you just confirm for me, do we have any resolution of the case?
No, we do not.
All right. So that means, Mr. Beebe, I have to have this conversation with you. If I've had it with you in the past, forgive me for repeating it. I just like to make sure that it's clear on the record. That's why. What I'm going to say has no impression upon me. It has nothing to do with what I think about the case, because I don't really know any alleged facts. I just know what the charges are on the documents in front of me. That's it. So nothing I'm saying is any interpretation of facts, calling with the facts, the likelihood of conviction or not conviction, anything. It's just to make sure that you know the decisions that you are making. The court gives a final pretrial conference day to enter a plea less than what's charged. Now, that's never to say, or I'm sorry, to punish a defendant for not pleading guilty or whatever. It's not even to force you. It's actually nothing to do with you. It's really to make sure the attorneys, Mr. Hartel and Ms. Smith, have done all their best that they can do to negotiate the case. Because what we don't like is somebody saying, well, I waited to the last minute, let me enter a better deal today. And then I'm stuck with losing one of the trial dates on the calendar. And I only can do about 24 trials a year. So I don't want to lose that date. And so it really is the force of two of them to have exhausted all their arm wrestling skills. And they have told me they have exhausted all those skills. Now, the next thing here is, it's also because I need you to be prepared for that trial date, right? Mentally, you've got to know, what am I going to do? Am I going to plead? I'm sorry, am I going to testify, not testify, so forth. Also, the prosecution needs to call witnesses. They subpoena witnesses. Mr. Hartel may have witnesses. Plus, the court has to bring in, and based upon the nature of these allegations, the court's going to bring in at least 3, potentially 4 panels of jurors. That's 120 people, right? And all those people have to take time off of work, get people to watch children, get a spouse to take off time of work. Somebody's got to take care of grandma. If grandma's elderly and needs care. So that's why it has nothing to do with you. It's just to make sure that we know we're getting ready to hold a baseball game in this stadium. Really is what it's about. You understand?
Yes.
Okay, good enough. Again, take nothing I say as any opinion about the allegations. All I know is that you've had some medical health issues and what you're charged with. First of all, how are you doing? Back there, it looked like you were a little blue.
Yeah, I'm not feeling very good today.
Okay. Well, now I want to highlight on that, or highlight something on that with you. I think I've talked about this in the past. We have to get this case going. Everyone has the right to a speedy trial and want to get this going. I'm not going to stop the case and don't take this wrong, in unproven medical emergency. Notice I said the word unproven. If there's a medical emergency, then okay. But I'm just telling you, so mostly Mr. Hartel knows, if he gets a notice that, hey, Mr. Beebe is not available, I'm going to want a report from the hospital saying, I'm Dr. So-and-so or nurse so-and-so. Mr. Beebe is in our facility and he ain't going anywhere. I don't know if that had a double negative. Anyways, you know what I mean. All right, any questions, Mr. Beebe? No. All right, anything further on behalf of the defendant today, Mr. Hartel?
No, thank you.
Anything further on behalf of the people this morning, Ms. Smith?
Your Honor, if possible, I would like to just put the final plea offer on the record and have Mr. Beebe affirmatively reject that.
You go ahead and state for us on the record what the final pretrial agreement offer was.
Thank you so much, Your Honor. In exchange for a plea of no contest in this case to counts 3 and 4 as a habitual second offender pursuant to 769.10, the people would dismiss counts 1 and 2, which are the life offenses with the mandatory minimum 25 years. Furthermore, we had negotiated a sentencing agreement with the defense that if that plea were to be accepted, the defendant would serve a fixed minimum of 180 months or 15 years. He would be required to register as a tier 3 sex offender pursuant to statute and would be placed on electronic monitoring upon release from MDOC pursuant to statute. That offer also encompassed 2 other cases outside of this jurisdiction that Mr. Beebe has pending. Upon that plea in the 55th Circuit Court of Clare County in case 2021-6625 FH. If defendant would plead guilty to the probation violations that are pending, the people would recommend revocation of the 7411 special status, but ask for time served as a sentence rather than seeking additional jail or prison sentence. And in case 2025-278 FY in the 80th District Court of Clare County, the people would dismiss that complaint completely without prejudice, as long as the victim in that matter was afforded an opportunity to provide a victim impact statement at the sentencing in Wexford County. So essentially that plea deal was to resolve all 3 of Mr. Beebe's pending matters and get everything wrapped up. My understanding, as the court has said so far this morning, is that Mr. Beebe does not intend to accept that offer.
All right, Mr. Hartel, is that what you understood the last offer to be?
Yes, Your Honor.
Thank you. Mr. Beebe, do you have any questions about that offer?
No, sir.
All right, so you've talked about it with your counsel.
Yes.
And your understanding, again, just to reaffirm, you are not accepting that. Again, I don't know anything about, heck, all those other cases or whatever she was talking about. All right, thank you very much. Also, Mr. Beebe, I know we had some bond issues in the past. You're not going to McDonald's, are you?
No,
All right, good enough. Stay away from McDonald's. I don't think it's going to help your health. Thank you very much. We are adjourned here on our trial date on August 12th. That's a 1 and a 2. Thank you.
Thank you, Your Honor.
Thank you, ma'am. Our next file is People of the State of Michigan versus Derek Christensen Bailey. This is case number 25-14072 F8. Appearances, please.
Joanna Carey for the people.
James Dick on behalf of Mr. Christensen Bailey.
You may have a seat. We're here today for a final pretrial conference. I had the opportunity to discuss that in chambers with counsel. Counsel informed me of a pretrial agreement. Ms. Carey.
Thank you. It's my understanding the defendant will plead guilty to count 1, possession of methamphetamine. The people will dismiss the second subsequent notice and the habitual offender 4. It's also my understanding defendant has been accepted into a treatment program and the people will not oppose him going there. I don't want to necessarily call it a delay of sentence, but something where if he did not complete that program or was involuntarily released from that program, he would return to the court for.
All right. I think, and we talked about conditional sentencing, delays of sentence. I think probably the best approach would be a delay of
Sentence.
Yes. Yeah. There's a couple alternatives. Ironically, I was looking at this week because I didn't have a trial, so I had a couple days just sitting around. I'm researching a bunch of issues. And one of them is, I don't necessarily think courts have the right to pull, or judges have the right to pull a sentence in advance. And it's just semantics. I do think courts have the right to suspend a sentence. But I think probably the best way here would be to do a delay of sentence. All right.
That would be fine.
Mr. Dick, do you agree?
Yes, Your Honor.
Is that what you believe the pretrial agreement is?
I do.
All right, good, thank you. All right, Mr., what would you like me to call you?
Mr. Bailey, fine, sir.
All right, thank you. All right, Mr. Bailey, is that how you wish to resolve it?
Yes, sir.
To the best you can, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. All right, Mr. Bailey, looking back here at March 26th of this year, were you on probation?
I was on parole, sir.
Parole. In fact, you're still currently a parole hold.
That's correct.
And were you on bond pending any other felony charges anywhere?
No, sir.
Now, all that is trying to help me determine what impact the sentence would have in any other case. So you understand that if you are found guilty here based upon a plea, that could be used against you by the parole board, which is operated by the Michigan Department of Corrections. In other words, not the court.
Yes, sir.
Now, I know Mr. Dick has reportedly spoken to your parole officer, which is what I would expect. And I asked him those questions because obviously I'm concerned about what would happen with you on parole. He's told me that, again, he has spoken with your parole officer and they seem to be this person seems to be in support of this resolution. Is that what you understand?
Yes, sir.
Okay. All right. We're going to be trying a program that Mr. Dick has brought to the court's attention from downstate. So you are our guinea pig. Let's hope it works out. So here's what we're going to do. I'm going to tell you what the charges are. I'm going to tell you what the plea agreement is, and then we're going to go through what happened. So currently, right now, you are charged on a felony information with a single count. That count is a charge of possession of methamphetamine. That charge is a felony punishable by up to 10 years and or up to $15,000. Now, there are two sentencing enhancements here that are within the discretion of the court. One, you could be sentenced as a second habitual drug offender that could increase that maximum punishment from up to 10 to up to 20 years, and from up to $15,000 up to $30,000. Or in the alternative, you could be sentenced as a fourth habitual felony offender. That could increase that maximum punishment from up to 10 years to up to life. However, if you plead guilty to count one, the prosecution agrees to dismiss the two enhancements, which means you would face a maximum punishment of up to 10 years. I'm going to go about this a little bit differently. I'm told that the attorneys, estimate the minimum end of a felony sentence according to the Michigan sentencing guidelines is either a 10 to 23 or a 19 to 38, I think. Now, first of all, the Michigan sentencing guidelines are not mandatory. They are a valuable tool to help establish what a reasonable proportional sentence may be. But again, what they have presented to me is merely an estimate. We don't know exactly what the scoring would be. Now, based upon your prior criminal history, we can pretty much tell that on the prior records variable line, you're all the way to the right. So it's only whether or not you score one other variable on an offense variable that brings you from the 10 to 23 down to a 19 to 38. But again, that's all just an estimate, although I'm going to say it's probably a pretty reasonable estimate. But that's just an estimate. You understand? Okay. Now, again, I'm told if you plead guilty to that count and I accept that plea, there's going to be an agreement. And that agreement is a Killebrew agreement. Explain that. There are two.
Present before the court is Mr. Fleischer, represented by Ms. Diefenbach, and we have Mr. View from the prosecutor's office. Can you hear me okay, Mr. Fleischer? I know you have some trouble hearing.
Excuse me?
Can you hear me okay?
Can you talk a little louder, please?
How about now? Can you hear me okay?
Yes,
all right, let's go with this then. So we're set for trial here in a few weeks, and Ms. Diefenbach tells me that you are not happy with her representation and want a different lawyer. Is that right?
Yeah.
Tell me what's going on.
Okay, Your Honor, I want to explain what I just explained to my attorney. I have been reviewing the law of Ohio and anything that it can be helpful towards my case. I have found that Ohio Revised Code 2929.41A says that any person who is incarcerated and catch a case, the time that it be given to that person, it has to be run concurrent with, according to the law. I don't know if you want to honor that. I don't know if the prosecutor want to. That's okay. I'm not here to just argue that. The second thing is, say for example, I was to accept this 6 months deal. I've been fighting the case since February, I believe February 5, I was indicted. Since that day into this day, it's been 5.5 months. That would be jail time credit. They'll succumb for jail time credit. Another thing, I cannot pay no court. It says here $5,000 fine. I can't pay no court fines, no court costs. I'm an indigent. Another thing is, first of all, I want to apologize to you for any misunderstanding or anything. I don't want to make it hard for you. I'm tired of going back and forth and trips. I would like to I can argue. I know what happened. I got pretty roughed up that day. You know, I got shot with a tranquilizer, all type of things. Everything was handled the wrong way. My whole point is, now supposedly videos ain't being shown up. There's no video, body camera on an officer at all time. I can tell, and I know for a fact that something is getting covered up here. I do not want to argue with these people. I don't want to waste your time, my time. I just want to get this done. But I am willing to take the 6 months deal if you at least consider, according to the evidence, if you can consider that you can run in 6 months concurrent with my time and honor the Ohio Revised Code 2929.41A, and we can get it over with. If everybody's happy, I will stand up in this courtroom and give my apologies for whatever happened. I'm not here to judge nobody, point fingers to nobody, anything. I just want to get this over with, Your Honor. I'll be honest. Like right now, another thing that the police officer did, like I was just telling my attorney, say for example, I'm not saying I'm going to do it. Say for example, assault your sheriff officer. If your sheriff officer get assault, she's going by law. It is required that she file charges right there and then the same day that the incident happened, and explain everything and bring up the witnesses and everything. Now it come back to me. This officer in the hospital, he took 2 days after the fact to decide to charge me. 2 days. After that, he bring in a whole bunch of, according to my motions of discovery, there's a couple of witnesses that is backing him up. Who is to say that this man didn't sit with each of these witnesses and told him, listen, I'm going to say this and this and this. You back me up on my story. You be my witness. They nurses, they co-workers, they people that are going to back him up on that. I ain't considered a criminal. So they're not going to vouch for me or defend me for whatever happened in the hospital room, how I was roughed up, how I was mishandled. Okay. Another thing, I just want to, the law is the law. If I break the law, I'm willing to pay for it. But in here, you can see a whole bunch of cover up. How is it possible there's no video camera footage or everything? There's cameras like this, like in this courtroom. Anything happen, cameras everywhere. These officers wear body cameras. You see what I'm saying?
So here's where we're at on this, Mr. Fleischer. So for example, that camera right there that you just pointed to,
yes, sir.
That camera doesn't record. So you may think to yourself, oh, there's a camera, and as a result of that, there's a recording. That camera doesn't record. You might look at this camera behind me to my shoulder there and think, oh, there's a recording of that. And then you go and look for it 30 days later, and it's not there because it records over things automatically every so often. So the fact that there was a camera there does not necessarily mean that there is a recording. But what's being represented to me is the state of Ohio says that they have looked, right, Mr. View?
Yes, Your Honor.
And they have made an investigation, and there is no video or audio recording of this incident. Now, you may say that there's a cover up to that. I don't know if there is or there isn't, but all I know is that people have investigated it, and they tell me that there is no video. Now, if something comes up in the trial and somebody says, oh, well, I watched the video or I saw it on the video, it turns out that there is a video, or you establish to me that there is some video out there that's being hidden from you, then I'll do something about it. But just this general sense that everything that happens in a hospital or in a courtroom or in a government building is recorded, that's not necessarily always the case, because what we find are body cameras. They're not always on, for example, and they don't always capture everything. So I don't know what to tell you in that regard. So there may not be video, there might be, but the state of Ohio has represented they have made an investigation and there isn't one, and you don't have any facts or any evidence that contradict that. So that's what I'm stuck with. Do you understand that?
I understand what you
and also to address your point about wasting my time or making things difficult on me, this is what the people of Warren County pay me for, okay? So you're not making this more difficult on me. You're not making my life harder or anything. I just want to make sure that everything gets done correctly. So I really don't hold that against you, and I don't want you to think that I do. The problem, though, that we have in this case is we have a trial date that is set here in a few weeks. And the last time we were here, there was some discussion about getting some medical records that you thought were important for your case, and we don't have those medical records. And so we're trying to figure out whether or not we're going to go to trial, whether or not I'm going to appoint you a new lawyer, or whether or not we're going to work out some sort of deal. Now, the statute that you're talking about is the statute regarding concurrent and consecutive sentences. And essentially, the law of Ohio is that concurrent sentences are the default position. So if I impose a sentence on somebody, it has to be concurrent. But the remainder of that section is a bunch of excepts. So a concurrent sentence has to be, or a sentence has to be concurrent, except where I find that the circumstances require a consecutive sentence. So if I make those findings, like you're incarcerated for something else, or a consecutive sentence is necessary to properly punish you or to protect the public, as long as I make a finding that the overall sentence is not disproportionate to your conduct or the danger that you posed, a consecutive sentence would be appropriate in the case. But if I don't make any of those findings, 2941A provides that if I don't make those findings, or it's a misdemeanor, you can never make a misdemeanor consecutive to a felony sentence. Well, you can't say never because of the new failure to comply. Anyway, if I make the proper sentence findings, then I will impose a consecutive sentence. So it's not, the law doesn't say that I have to give you a concurrent sentence. The law says that I have to give you a concurrent sentence unless I find certain things. And it seems to me that those things that I would find are present in this case, like you're already serving a prison sentence for somebody else. Do you understand that?
Yes, sir.
So the offer, as I understand it, is to enter a plea of guilty to this charge and do an additional 6 months, right? Is that the offer?
Yeah, correct. And we agreed if he pled his charge,
Yes,
the
Your
state
Honor.
would recommend a minimum consecutive sentence.
You don't get jail time credit for that sentence because it's consecutive to the time that you're doing. So all of the time that you're doing, I think it's a robbery charge or a burglary charge from Cuyahoga, right?
Excuse me, Your Honor. How do I not qualify for jail time credit when I was given a $30,000 bond?
Because
And I
you're
never
already
posted.
serving a sentence for somebody else. So what the law says, Mr. Fleischer, is you get credit for every day of jail time that you do somewhere. But if you're being held on bond, but you're also serving out time for somebody else, you do not get jail time credit for that unless you receive a concurrent sentence. If you receive a concurrent sentence, then you would get jail time credit. Do you understand that?
You say only concurrent sentence?
Only if I give you a concurrent sentence would you be entitled to jail time credit for the time that you're doing being held in lieu of bond.
Your Honor, can I please ask you, beg you, ask you for an opportunity to accept a plea deal if you can find it in your heart and according to the situations and circumstances, can you please let me plead guilty if you decided to give me concurrent sentence? Please. This is what I would like to ask you and really do. Plead guilty if you promise me to give
I'm not going to make that promise to you, Mr. Fleischer. What I will promise you, we can do a couple of different things. I mean, you're going to be basically pleading as charged. So the state of Ohio is not reducing any of the charges in this. They will have a say in the sentencing. What I can tell you is if you would like, because you're done with your Cuyahoga County sentence when? In December? If you want to enter a plea of guilty to this charge, and then in December, I'll put a holder on you. You can come down here and I will do a pre-sentence investigation. We'll look into your history. We'll set it for sentencing. We'll do all of those things. And then I will look at a PSI and I will decide whether or not you get, I mean, that's the best I can do for you. I am not going to promise you a concurrent sentence. That's just not going to happen.
So
The other option that you have, Mr. Fleischer, is instead of bringing in a jury on the 14th, you can waive your right to have this case tried to a jury, and I can hear the case instead of the jury. If I find that you are guilty, if the state's able to prove all of those things, then I would actually know what happened, and I would be in a better position to decide whether or not I'm going to give you a concurrent or a consecutive sentence, assuming that I find you guilty. That's the other way that this case could go.
So right now, let me see if I'm understanding you correct. You're not willing to give me 6 months concurrent right now?
No.
And if I take 6 months right now, you're not willing to give me my jail time credit I've been fighting this case? Neither.
I will give you any jail time credit that you are entitled to by law, but my understanding is you're in prison for another charge. So if I were to sentence you to a consecutive sentence, you would not be entitled to any jail time credit because your time won't start until after this is over. But if, for example, I were to give you, if you pled today and I were to give you an 18-month prison sentence, then you would get jail time credit if it were concurrent to the time that you're already doing. You would get jail time credit for a concurrent sentence.
Wow.
But I got a trial coming in. I got a jury coming in on the 14th, Mr. Fleischer, for this case. I need to figure out what we're doing. Are we going to trial on that date, even though we don't have the medical records?
The medical record has to be subpoenaed. I already asked for.
I know you did, and I didn't do it, and I
Already
I
asked
failed.
for the videos and everything.
Well, the videos I can't do
There are
anything
6.
about.
They just don't want to bring them up. It's impossible that I'm in a private hospital and none of these videos are shown because what really happened doesn't want to be exposed in your courtroom in front of everybody. They don't want to embarrass themselves. They don't want to bring it the truth. Like I said, I have a mother that is sick. I'm trying to go home when I'm supposed to go home. I can't afford to keep doing more time in prison. My mother is sick. My mother has heart problems. She's lonely in Florida.
I want to stay. I want to stay focused on this, Mr. Fleischer, because I'm not discounting what you're saying, but what you're saying about your mom being sick and all those things, those have nothing to do with whether or not you are guilty. Hold on, Mr. Fleischer. Only one of us talk at a time.
Yes, sir.
What you're telling me about your mom being sick, that doesn't have anything to do with whether or not you are guilty of this. And you are 100% wrong that if you think that I have any interest in protecting people at Atrium or protecting people in law enforcement or protecting people if they are hiding something from me, I promise you I am much more interested in getting to the bottom of that than you are. But I will tell you, you and I have something in common today. We are both very disappointed and a little upset that nothing has happened in your case since we were here in April. Ms. Diefenbach was supposed to get some records and she didn't. I'm not happy about that, and I know you're not happy about that either. The reality is, though, if I take her off of this case and I appoint you a different lawyer, I'm going to have to move your trial date, which is set for August the 14th. I can't bring in an attorney and have them ready to go to trial here in just a few weeks. But if you want somebody who is going to work harder for you in the case, I will appoint somebody else for you and I will get you a different lawyer. Is that what you want?
You mean give me a new lawyer?
I would appoint you a different lawyer. That way your lawyer could do a better job investigating it to your satisfaction than Ms. Diefenbach has been doing, but that means that I'm going to move your trial in August.
I got a question. What's going to happen if I take a 6 months plea deal today?
If you want to enter a plea of guilty to this, if you want to enter a plea of guilty to this charge, I will sentence you to 6 months in prison consecutive to the time that you're already doing, and I will make a finding that you are indigent, so there is no financial sanctions, no fines, no costs.
So that means I got 6 more months on top of what I got remaining?
Yes.
This don't even make no sense. And why you say you can't give me the jail time credit?
I didn't say that I can't. I'm saying that you're not entitled to it because your sentence doesn't start until after you're done with your Cuyahoga County sentence. So you're not entitled to jail time credit.
Right now, while I was in prison.
Yeah,
If it was person, according to the law, if it was personal bond, I'm not entitled to no jail time credit. But I was given a monetary bond, $30,000 bond. I never posted. I'm in jail fighting the case from prison, from jail. I'm still getting home. So every day I'm fighting the case. It counts as towards jail time credit. That's what the law says.
It doesn't, Mr. Fletcher, because what the law says is that even if it weren't for this case, you would be in jail anyway. That's the way the law looks at it. If you want to appeal the issue of jail time credit, 100%, I will make the findings. You can appeal that, but it's been litigated. You know, if I'm wrong, I'm more than happy to give you the jail time credit if the Court of Appeals tells me I'm supposed to. But my understanding of the law is, and this has been litigated pretty heavily, the law looks at it that says if you are not in jail because of this offense, you're not going to get jail time credit. The exception to that is if the other place is not giving you jail time credit. You get 1 day of jail time credit for every 1 day that you serve. You don't get it. Essentially what you're saying is I get credit in this case and I get credit in this case, so I get 2 days of credit for every day I serve. That's not how the law is set up. What I need to know, Mr. Fletcher, is what I'm doing with this case. Am I having a trial on the 14th? Am I appointing you a new lawyer? Do you want somebody to investigate this more thoroughly than has been done? If so, I'm prepared to do that today.
What you think, Ms. Marcel?
Well, can you hear me? My understanding is you apparently kicked the guy when you were in the ambulance, so they wouldn't have had a chance. That's one. Two, you're not gonna do any better than this today. You're not gonna be found not guilty, that I can tell. So I think this is probably one of the better deals I've seen around. And I'm not sure the medical records make any difference. So we could go ahead for trial even without medical records because they're going to testify why you were there. But I think the actual kicking took place when you were going.
So what he's saying is if I take the 6 months deal,
Yeah.
I am not gonna be given jail time credit.
That's right. And legally, he doesn't have to do that.
Okay, and when I go to trial, you are willing to ask and cross-examine the officer why he did stuff, how he did the process, and
Yeah, but
all this can be brought up to trial. The jury will know that there's cameras in the hospital, but they
But the
don't
thing
want.
is, it didn't happen in the hospital.
Huh?
It did not happen in the hospital. Am I correct?
This happened in the hospital.
Hold on. Mr. View, did the actual assault occur in the ambulance?
No, it occurred in the hospital.
It did occur in the hospital, because I thought we discussed it.
My understanding is that following his transport from the hospital to Columbus, there was an additional assault on corrections officer. That's a separate case. That's a separate circumstance. I don't know. It's not brought in our county, so I don't know anything about it. But I did concern after our conversation in April, I spoke with the lieutenant at Atrium. Their officers do not wear body cameras, and there are not cameras inside the examination rooms. And I also spoke with ODRC. There is no body camera from the corrections officers because it was an ambulance transport. It was not taken by transport by corrections facility officers. So officers accompanied him. There's not body camera from the corrections officers that were present. So I did follow up on your request.
I know you did.
So, and I did communicate that information to you in April.
Where did the assault occur?
This is the assault that happened to the police officer who was an Atrium police officer at Atrium Hospital.
Okay.
In the hospital, see? So there's cameras in the hospital.
Well, no, they're not, according to them.
There's cameras in the room and inside the hospital. According to them, that's what they lying. That's what I'm saying. I'm telling you, they are. There's
Mr. Fletcher?
There's hospital. In the hospital room, there's cameras on top of the ceiling. There's cameras like that. Little bubble cameras like that. Everywhere. The officer that was handling the situation, he had a body camera like that.
Did he have it on?
He had a body camera.
No, did he have it on, the camera on?
It should have been on.
Not necessarily, they have to turn it on. It's not automatic.
So, Mr. Fletcher, where are we at on this? Do you want me to appoint you a lawyer that is going to investigate this case more thoroughly? Or do you want to go to trial on the 14th?
If you do that, when will I'll be back to come see you? A couple months later?
I'd like to get it set as soon as we can, probably in 2 or 3. What I would probably do, actually, is if the new lawyer is available, I would leave it set on the 14th because we already have a transport order for you. And we'll set it for hearing sometime in the next few weeks after you meet with the new lawyer.
And you could do 18 months.
Huh?
And you could do 18 months if you're found guilty.
I would do 18 months.
You could. I don't know if you would, but you could do 18 months if you were found guilty. So instead of doing an additional 6 months, you could do an additional year and a half.
But a jury, it is the jury's duty to find me guilty beyond reasonable doubt.
Yeah.
It's just his word against mine. Right now, they don't want to even bring up the cameras. They don't want to present it, and there's cameras going on.
Well,
that's what I'm saying. I feel like
I'm not sure there would be cameras because
there's cameras in the hospital. It's a private hospital, Miss Roseanne.
I know, but the hospitals, what occurs in a hospital is supposed to be confidential. Medical stuff is confidential. So recording it, they would make it non-confidential, wouldn't it?
No place, no government place will have camera. Just
It's not a government place, it's a private hospital.
They got cameras. So they trying to find me.
Mr. Fletcher, what do you want to do? Because you keep pointing to that camera as the example of something that is recording, and I'm telling you, I'm the one that had that camera installed. There is no recording that comes from that camera. It runs to a bunch of people. Somebody might be watching it, but your basic premise in this case is flawed, that just because there's something that looks like a camera, there must be a recording. That's not true. But if you want me to appoint somebody who is going to do more work than asking the prosecutor if he talked to somebody at Atrium, I'm willing to do that if that's what you want me to do. But you seem to be telling me that's not what you want me to do, that you want to go forward with Ms. Diefenbach. If that's what you want to do, I'm okay with that also. But the fact that you're arguing a point that you have no idea if what you're saying is true, and you just speak it as if it's true, there's got to be a recording because I think there's a recording. That's not going to get us anywhere. If you want me to get you somebody that will go look for the recording, I'll do that. But we are at an impasse here on there must be a recording. No, there's not. Do you understand what I'm saying?
This is crazy, man.
If you want to see your mother, I think you should take the video.
This is crazy to do 6 extra months for something I'm being accused of. And they can't even prove it.
Well, they have testimony. And in actuality, the officer is probably going to be more credible than you. I sent you the, I sent you.
Your Honor, I have a question. If there's any way I can accept the 6 months deal and receive probation, but when I get out, be in parole and probation. If there's any way I can receive probation from you, I can do programs, anything you want me to do, community service. If there's any way you can align this to where I can get released in December 27, but I'm going to be adjusted to probation and parole. Right now, I'm facing PRC. I can be put in probation, and you can give me house arrest.
Mr. Fletcher, if you want me to do any of those things, then you're going to have to enter a plea of guilty to the charge, and then I'll do a pre-sentence investigation, and I'll come back and I'll impose whatever sentence I think is appropriate. If I think probation is appropriate, I'll impose a sentence of probation. If I think a 6-month sentence is appropriate, I'll enter a 6-month sentence. The caveat, though, is if you enter a plea to a joint and a recommended sentence, that means that I cannot impose an 18-month sentence or a 12-month sentence consecutive to the time that you're already doing. If you enter a plea of guilty to this charge with no joint and recommended sentence, I may find, having looked at your background and your history, that you need a sentence longer than 6 months. I don't know. I may look at the PSI and say, I can put him on probation. That usually doesn't happen in these kinds of cases. I'll tell you that right now. But if you want to enter a plea, but if you think that I'm going to promise you anything other than I'm going to look at the PSI and give it the credit and the weight that it's due and decide what I think an appropriate sentence is, if you want a promise of more than that, you're not going to get it.
And if I go to trial on the 14th and say I was to lose trial, I'm facing 18 months.
If you are convicted after a trial, it's no different than if you enter a plea of guilty. I could still sentence you to probation. I don't have to. Seems unlikely based upon what I know about this case. You don't automatically get the maximum penalty just because you take it to trial, Mr. Fletcher. That's not how this works. But I'm going to listen to the testimony, and it might be during that trial that this seems like a lot worse than what I know is true, and I may sentence you to the maximum penalty. I may consider the fact that you're not really accepting responsibility is 18 months in prison consecutive to the time that you're already doing. But I might see the facts, and I might say, a 6-month consecutive sentence is appropriate. I might look at the facts, even if the jury convicts you, and I might say, a 6-month concurrent sentence is appropriate. Just because you go to trial doesn't mean that it changes the equation on what I sentence you to. But the danger that you have if you go to trial is A, you're not accepting responsibility for your actions on that day. And B, I might hear something in that trial that makes me think that you need to be away longer to protect people from you. Those are the downsides of you going to trial. But I don't really have a lot more time for this case, Mr. Fleischer, today. I need to know what you want to do. Do you want to go to trial on the 14th with Ms. Diefenbach or not?
It's obvious. The judge don't want to help me out with this, and I want to make it easier. Forcing my hand to go to trial. We're gonna have to go to trial because this is out of the question. I need you to file for the medical record for OSU, medical record where I was at a hospital.
Well, where did this occur?
This occurred in Lebanon Hospital.
That's what actually, I think it's Franklin.
Yeah, but from
what does
Lebanon
OSU
Hospital,
have to do with it?
From Lebanon Hospital, I went to OSU for surgery on my nose because I got punched by a police officer, by a correction officer. So that's why I was in the Lebanon Hospital at first. I was punched inside the ambulance on my way to Lebanon Hospital.
All right, here's what I'm going to do, Mr. Fletcher. I'm leaving your trial set for the August the 14th. I'm going to set this for a conference a few days in advance of that, maybe the week of the 11th or the end of the week on the 7th or the 8th. I'm going to set it for a conference, and then we'll talk about this more then.
Your Honor, I'm on vacation. I'll be gone August the 1st. I won't be back until the 11th.
We may have to need somebody to cover it for you then. All right, I'll see you at the conference, Mr. Fletcher.
When?
I don't know. I don't have a date yet. Do we want to get a date while we're here? How's the 12th?
What can we do?
Are you available the 12th, Ms. Diefenbach?
I'm available on the 12th. I'm available on the 12th, August 12th.
All right, let's set it August the 12th with every other thing that we have that day. How about 11:30?
11, hold on. Let me write this down and then I'll walk out with you.
All right, August 12th, 11:30.
If I plead guilty today, this case get closed with, and then the sentence start when?
It will start December the 25th or whatever.
December 27th is my out day.
Yeah, it would start when you're done with your other.
And I'm not allowed to file for judicial or anything like that.
You can file for judicial.
You can always file for judicial.
It's not guaranteed to get a judicial.
It is not guaranteed.
The only thing guaranteed is that you would get 6 months at the end.
You know what? I think, so if I plead guilty today, I don't get court costs, no court fines?
That's right.
No, but you also have the opportunity to do that on the 12th too, if you want, Mr. Fletcher. If you want to think about this more and you want to enter a plea of guilty to the charge on the 12th, I'll give you the exact same sentence that we're talking about today. So it probably makes sense for you to take some more time and think about what you want to do.
So basically you're giving me a little bit of time to make up my mind.
Yes.
Yeah.
Today's the 25th.
That's about
You know
15
what?
days.
You know what, Your Honor? Man, part of this want to get this done with.
That is the worst reason to go forward with a plea that I've ever heard in my life, Mr. Fletcher. Think about it. Let's talk about this again on the 12th.
I'll call your sister and we'll talk.
Ms. Diefenbach is going to undertake to get the records between now and then.
Should I be honest with me? Should I take this 6 months?
Yes, you
right
should.
now and get it over?
Yes, you should.
You know why?
You feel in your heart that I should do this.
Yes, I think that's in your best interest because you've read the records. I sent you the records originally.
Okay.
And I'm assuming you got them, although I think they censor your mail there. And it isn't a pretty story. You were kind of out of control.
Your Honor.
So I think it would be a good idea to take this deal.
I'll take those 6 months. I'll take.
All right. We're going to get a plea form typed up, or do we have one already?
I read it right now, Judge.
All right.
I think it's in your best interest. However, I could see where they had to set your nose.
Do we have enough, Deputy,
Yeah,
do we have enough staff to bring Mr. Elliott over while we're waiting? Okay.
I think we do.
Is that the plea form?
Well,
Yes, you don't see that I can win this in trial?
no, you're not going to win this in trial. You read, I did an extra set of, thank you. I did an extra set of this for you too.
No.
Because I actually sent this to you originally. And it just slides.
All right, we are back on the record in Mr. Fletcher's case.
Oh, okay. Sign your name right there. And sign your name right here, and I'll finish it.
Did we find Mr. Williams?
This is indigency. an indigency affidavit. You don't have any money. Okay, let's go do this one.
Mr. Fleischer, how old are you?
I am currently 36 years old.
How far did you go in school?
Excuse me?
How far did you go in school?
9th grade.
Are you able to read and write English? Is that a yes?
Yes.
Are you under the influence of drugs or alcohol?
Excuse me?
Are you under the influence of drugs or alcohol?
At this moment?
At this moment.
No, Your Honor.
Are you taking any medication that would interfere with your ability to understand what we're doing here today?
No, Your Honor.
Are you a United States citizen?
Excuse me?
Are you a United States citizen?
Yes, sir.
Other than what we have talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
Well, the only thing that was told to me in this court,
Right.
that you will be giving me 6 months.
Yes.
No more, no less.
Yes.
Consecutive.
Yes.
No court costs, no court fines.
Yes.
That's
You're going to
it,
be
Your Honor.
entering a plea of guilty to 1 count of assault. This is a 4th-degree felony. It's punishable by up to 18 months in prison. It also carries with it an optional period of post-release control of up to 2 years. That means that the adult parole authority can supervise you for 2 years upon your release. You already understand that because of your burglary charge, right?
PRC is mandatory with this?
PRC is optional for this, right? I don't have the plea form in front of me, but it's an
correct,
optional
Judge.
period of post-release.
I'm already going to be in PRC.
I would imagine that that is the case.
Okay.
Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. They have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the 6-month consecutive sentence. Is that what you want to do?
Your Honor, I'm accepting the 6 months.
All right. Do you understand the rights that you're giving up by entering a plea of guilty?
Yes, Your Honor.
What is your plea?
I plead guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Mr. View, anything from the state?
No, Your Honor.
Anything else you want to tell me about this, Mr. Fleischer?
Your Honor, can you please make sure my warrant, I have an open warrant for this county to be cleared out because
It will be cleared, yes.
And will you let them know I'm no longer needed so I can just go back and
I will let them know.
do my time, and I guess this is over with. I don't have to come here.
You will not come back here after this for this case.
Okay.
All right, I am going to sentence you to 6 months in prison consecutive to the time that you're already doing. A consecutive sentence is necessary to properly punish you, to protect the public. The overall sentence is not disproportionate to the conduct involved here or the danger posed by you. I do make a finding that you are indigent for the purposes of fines and costs, and this is going to include the optional period of post-release control. What do you want to tell me, Mr. Fleischer?
How did that work for me to file to get jail time credit according to the law with this? Because you're not going to give it to me.
You're going to get an entry that says that you have 0 days of jail time credit. If you want to appeal that entry, you can file a notice of appeal within 30 days.
So that means I got to go wherever I'm going, file a notice, a special motion.
Yes, you need to file a notice of appeal. Do you want to appeal your jail time credit?
Yeah, I want to
Okay,
know.
Ms. Diefenbach, will you go ahead and file a notice of appeal? She won't be your lawyer for the appeal, but she will file the notice of appeal.
Yes, sir, I can do that.
Okay?
So you'll let me know.
I'll send you a copy of it.
Okay. That's it, Your Honor.
All right. Good luck to you, Mr. Fleischer.
Thank you.
Where did Mr. Williams
How
go?
will do this?
I will do this and I'll call Jessica.
regarding the sentence. Imagine there's a triangle between you, the prosecutor, and me. If it's a Cobb's plea, then there's a full triangle. I agree today as to the sentence. If it's a Killebrew, I'm no longer in the triangle, it's just a line. It's an agreement between the two of you. And then if at the time of sentencing, I don't go along with it, then you have the right to withdraw your plea. That's the difference. So instead of a triangle for a Cobb's, it's just a line for a Killebrew. Got it? All right, good. So by entering a plea of guilty today, you're not going to have a trial of any kind. Does that make sense? I'm holding up a piece of paper that your attorney just provided to me a couple minutes ago, and at the top it says advice of rights, and at the bottom it appears to have your name and signature. Is that your signature?
Yes, sir.
Did you read through these rights before signing?
I did.
Did you understand what you read?
I do.
And even most importantly, do you understand that if you plead guilty and I accept that plea, you will be waiving those rights?
Yes, sir.
At least as it applies to this case.
Yes, sir.
All right. Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. Had there been any other threats, promises, by you entered the plea of your own free choice? Okay. Now, the Killebrew portion that I set up on the tee, but I didn't swing at it yet. Now I'm going to tell you what it means. That you be placed upon a delay of sentence. Court can, pursuant to a law, we don't need to know the number, but I'll just say it for the attorneys because it makes us sound like we're really smart. MCL 771.1 parenthetical 2. And it says that the court can place you on a delay with terms that are very consistent with probation. However, it's not really probation because the sentence is delayed. I don't announce the sentence. I wait. And I wait to see whether or not you earn the benefit of whatever leniency that the prosecution is giving. So is the leniency, well, we got to figure out what the leniency is. If he completes this 1 year for this program, is the charge going to be dismissed, or is there going to be an agreement to time served?
Correct. There's not going to be any other benefit other than not an immediate prison sentence.
All right, so there we go. So the recommendation would be a jail cap.
Well,
I'm sorry, there's
No,
an
if
agreement that it would be up to a year?
no,
Okay,
I'm sorry.
that's okay.
If he goes and he completes, time served.
Got it.
If he doesn't, then
Got it.
the
Thank
sentence will be whatever,
Thank you.
but there's no reduction.
All right. First time we're doing this, so we're putting together the language of this as we go. So typically in a delay of sentence, we might put somebody on a delay, and if they complete that period, which is up to a year, they get some benefit. Sometimes it's a reduction in the charge, which is not being done here. Or it's a specific punishment or sentence. Now, the agreement here is that you will get time served if you complete this program successfully. And you're not looking at further jail. You're not looking at prison, which realistically is an option, right? If you score a 10 to 23, the middle of that guidelines will put you in prison for 15 months. Don't criticize me on my math. I know it's not, that's like 16 months. Or if it was a 19 to 38, it could be 2 years. So if you go and you do this program and you successfully do it, which means you don't leave voluntarily without permission, or you fail the program, or you're kicked out for any reason, I turn yourself in, and if you don't, a bench warrant's going to be issued from you, right? Odds are you're going to sometime come here in a Cadillac, and I guarantee you, with this kind of record, most of those guys with lights on top of their car can probably identify you, and it ain't going to work out well. Got it? Yeah. And really what we're looking here, there's some part of me or part of the judge's job that says, by gosh, punish these people when they've got HAB-4s and all this kind of stuff. But the other part is that punishment's only one part of sentencing. The other part is hoping to change someone's life. How old are you?
46, sir.
46 is younger than I am. So You got a lot of life to live, and let's hope you figure this out. That's going to be our goal. And we're going to be very, very positive about how we go about this. Now, is that what you want to do?
Absolutely.
All right, good enough. All right, so do you have any questions before I ask you about the plea? Ask to count one. How do you plead? Before I accept that plea, I need you to tell me what you did that makes you guilty of offense. Now, I remind you, I don't think we're gonna have any problem here, but I remind you, you took an oath to tell me the truth. All right, so somewhere down the line, if this all falls apart, you can't come to me and say, I didn't really have the meth. Well, I'm sure it was in my pockets, but I really just found those pants laying in a dumpster and picked them up and put them on. By the way, people try that one. So, all right, so what happened on or about March 26th of 2025 here in the city of Cadillac, Wexford County?
I was at a friend's house and the East County team came, and when I got arrested, I had something in my pocket.
Okay.
Realized it. And then
Wait. Was it your pocket?
Yes, sir.
On your pants?
Yes, sir.
Right. And I'm not picking on you. I just want to make sure we're clear. And did you know that it was meth?
Yes, sir.
And how could you see it was it in the baggie, or tell me about it?
The police handcuffed me in the front, so when I put my hand on my pocket, I realized it was in there.
Okay. And what was it? I'm sorry. In what form was it? A baggie, a vial.
Yeah, it was a baggie, sir.
Thank you. You could see it or rub it between your fingers and see that it was there. And you knew that it was meth?
Yes, sir.
You may have forgotten it was there for a period of time, but you knew it was there and you didn't have any lawful reason to have it. And you didn't have any lawful reason to have it. Is that right? Ms. Carey, you believe he's provided the factual basis? Are you aware of any other promises, threats, or inducements?
I'm not.
You believe the court's compliance with 6.302.
Yes, sir.
Mr. Dick, do you agree with all three?
Yes, Your Honor.
All right, there's one small point. We want to get him into the program and we want to modify his bond. Or do we do the release at the time of the delay? That's one thing I realized we didn't talk about. Because, so here's what we can do. One, there's a bed available in the program now.
Yes.
If I release him, we come back to do sentencing where I officially put him on the delay. He has the right to be here, or he can waive that right. Or do we want to leave him in jail and then do the delay? By the way, we generally do delays for up to 12 months. If I put him into the program now, we have about 5 or 6 weeks where he's, sorry, don't take this as a negative, sir. I don't mean for it to, because we want to be very positive about this. This is all about helping you. He's very likely to want to behave. Yes, ma'am.
The parole hold.
But the parole.
That if you released him, he wouldn't.
I know, but thank you. The question is what happens if they want to lift the parole? So do I create a way now to modify the bond, which means it's up to parole if he goes? What do y'all think? So if I grant the bond now or modify it to a PR where he has to leave from the jail to the program with a free ride from Wex Express, then all you're doing is trying to figure out what the parole holder will do.
Yes, I was just informed, Your Honor, that he's had a discussion with his parole officer and they would be willing to release him with a GPS tether.
Okay, so by the way, if it's a GPS tether, they pay for it. It's not through community corrections. So there's another option. Option one, the court today modifies the bond. Oh, wait, hold on. The court hereby finds the defendant guilty of count one, find that his plea is made freely, knowingly, and voluntarily. Now the question is, what do I do with the defendant pending sentencing? Option number one, I declare that his bond is modified pending whatever parole does. And that means they're in charge of the tether. And then they're also in charge of what date he leaves. If he does that, then I'm going to ask for the defendant to waive his right to be present for sentencing so he can do it from the program. And then the other option is I leave them here and we deal with it in about a month. But I would rather help them get the benefit started now, because I know this program can go up to a year or even past. And I want to maximize the benefit of the program. What do you think, Ms. Carey?
I agree with that, but the people would like him to go from jail to treatment with no.
No. That's what I want to.
Okay. With no in between.
Okay, that's kind of what yes, that's how I envisioned.
Okay.
What I said meant.
As long as that
Okay.
doesn't happen.
All right, Madam Clerk, here we go. You ready? Court, and I know we have to go with the PSI report soon. Modify the bond to place the defendant on a personal recognizance bond. That he is to, when released, to be transported by Wex Express from the Wexford County Jail to Grace Centers of Hope in Pontiac, Michigan. With any conditions placed on him by his parole officer. He is to enroll in and successfully participate in their treatment program. If he leaves the program unsuccessfully on his own choice or is terminated from the program, he must return back to the Wexford County Jail. Mr. Bailey, you have the right to be physically present for sentencing. Now, we anticipate the sentencing will be in about a month. Between now and then, as you probably know from the past, you're going to get a packet. You're going to complete that packet and turn it into the Department of Corrections. They have to prepare a pre-sentence investigation report that will include a description of the offense, description of the pretrial agreement, any statements or information you make to provide while preparing that report, and make a recommendation as a sentencing, which of course is just merely a recommendation. I use the word merely. That's not to devalue the value of those people, but I'm the one that makes the decision. 3 steps. 1, you're going to prepare the packet. 2, you have the right to have your counsel present during the interview. 3, he's going to go over that report with you prior to coming back to sentencing. Now, you have the right to be physically present in the courtroom at sentencing. However, you can waive that, and I will allow you to waive it if you're at the program. So that way you don't have to drive 3.5 hours up here and 3.5 hours back, and then somewhere in the route get tempted and screw it all up, which we don't want you to do. Are you willing to waive that right to physically appear in the courtroom if you are in the Grace Centers of Hope?
Yes, sir.
All right. Mr. Dick, any objection to allowing him to appear via Zoom?
No, none, Your Honor.
And Ms. Carey, any concern with that?
No, Your Honor.
Did I miss anything?
That I would ask that the court require him to sign a release so that.
Oh, yeah, sorry, thank you. Mr. Bailey, I'm also, in term of the condition for releases, you have to sign, condition for the modification of the bond is that you must sign a release for community corrections in our building to monitor your attendance. Now, that release does not allow them access to any private health information. Like if you talking to your counselor, I want you to feel free to deal with whatever issue you've got. So I want you to know no one here will have any clue about what you tell them. That's all going to be private. The only thing that you're signing the release for is so the court staff can go, is he still there? Great, thank you. That's it. All right.
Can we expand that to community corrections and MDOC?
Well, and the MDOC, because they just need to make sure that you're there so they can, if they don't want to call, hey, listen, we need to finish the pre-sentence investigation report. Is the guy there? We can't tell you if he is or isn't. They need to be able to talk to you. All right, does that make sense? All right, so you need to sign a release to allow Community Corrections and Department of Corrections to monitor your attendance and make sure you're there. Now, as long as you are there in this program, and this is the first time, like I said, you're our guinea pig. As long as you're in the program, work in the program, this is gonna be great. You don't have to go back to jail or prison. That sounds probably pretty good. And most importantly though, hopefully we're helping you. All right, I really want to see that you know, even with this criminal history, there's a good chance you could get a prison term. And sometimes I send people to prison with these records because we don't have enough treatment locally. For a lot of reasons, for people probably who have purse strings in Lansing. But here, the prosecutor and defense have found a program for you. Therefore, let's use the program. Anything further today, Ms. Carey?
No, thank you.
Anything further today, Mr. Dick?
No, Your Honor. Thank you.
Any questions about what we've done, Mr. Bailey?
Thank you, Your Honor.
We'll see you. We're adjourned. Our next case is People of the State of Michigan versus Emily Southwick, file 25-14073, FH. Appearances, please.
Yes, Your Honor. Bill Burnett appearing on behalf of Emily Southwick.
All right, Ms. Southwick is making her way here to the defense table. Also here this morning is Ms. Joanna Carey, the Westford County prosecutor. We are here today for a final pre-trial conference. I spoke with counsel in chambers. They informed me that they believe we have a pre-trial agreement. Ms. Carey, the terms of the agreement, please.
My understanding the defendant will plead guilty to count one, possession of methamphetamine, and there is an agreement for treatment under 7411.
Thank you. Mr. Burdett?
That's correct, Your Honor.
Thank you. Ms. Southwick, is that how you wish to resolve it?
Yes.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. All right, Ms. Southwick, make sure everything you tell me today is the truth because I will forever treat it as the truth. All right, so back on November 1st of 2024, were you on probation, parole, or bond?
I was on bond, yes.
And for what kind of offense was that? Do you know, was it for a felony?
I was out on bond for possession in Manistee County.
And did that case get resolved?
No, not yet.
Okay, so prosecutor, you agree that the court, that you would support a concurrent sentence because it would be within the discretion, not mandatory consecutive sentencing, but discretion. Mr. Burdett, I assume you agree.
Yes, I agree.
That's important because if you're on bond for a felony and then you pick up another felony, any sentencing could, within the discretion of the court, i.e. me, run consecutive. You'd have to serve one sentence before you serve the other one. Because the prosecutor's agreeing that no matter what, you would run concurrently, okay? Which is a positive for you. Now, you are currently charged in the felony information with a single count of possession of the controlled substance methamphetamine. That is a felony punishable by up to 10 years and or up to $15,000. I'm told you're going to plead guilty to that as charged. So now you're wondering, well, what's the benefit to me? Well, the benefit is that you'll be reaching a Killebrew agreement with the prosecutor. A Killebrew agreement is just an agreement between you and the prosecutor about sentencing. And then, if I don't go along with it at the time of sentencing, you would have the right to withdraw your plea. If I do go along with it, then you're stuck with it. Okay. Now, if you enter a plea of guilty today, you're not going to have a trial of any kind. Does that make sense?
Yes.
By entering a plea of guilty, if this court accepts that plea, you'll be waiving certain rights. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question, cross-examine those witnesses, the right to have the court order any witnesses you may have for defense to appear at trial, the right to remain silent, the right to not have that silence used against you, and the right to testify if you chose to testify. Ms. Southwick, do you understand those rights? And again, do you understand if you plead guilty and I accept that plea, you will be forever waiving those rights as it applies to this case. Also, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing an application for leave to appeal and not a claim to appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today. Have there been any other promises, threats, or inducements to force or compel you to plead guilty? The answer plea of your own free choice.
Yes.
Now, there was one other term that I held on to, and that Killebrew agreement is that I would place you on Section 7411 status. Section 7411 is merely a section under what's called the Public Health Code. The Public Health Code is what lists all the drug crimes. 7411 is in the section for drug crimes, and it says that if you are eligible, and you don't have any prior convictions for drug crimes, the court can place you on a delay of sentence, or I shouldn't use the word delay, the technical word would be a deferred sentence. And it generally involves terms or conditions like probation. And if you complete that term and don't violate those terms, you have the right to have the charge dismissed. If you do violate them, then you could lose the status. You can't revoke your plea, and I can give you a sentence. Does that make sense?
Yes.
Okay. Is that how you wish to resolve it?
Yes.
By the way, what do you think the number one way is that people violate 7411 and lose that protection? If they go ahead.
They probably drop dirty.
Bingo. Yep. So don't do it, because I can almost guarantee you you're gonna be back in an orange jumpsuit if you violate it. Okay? Now, I'm not saying I'm gonna get it to you yet, but most likely you probably will. All right, you still wish to enter the plea of guilty?
Yes.
Ask to count one. How do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what you did to make you guilty of that offense. Turning your attention back to November 1st, 2024, in Springville Township here in Wexford County. What happened?
I was driving and I got pulled over, but I had some mess in my wallet.
Okay. And did you know it was in your wallet?
Yes, I did. When I got pulled over and I was going to jail for my no insurance tickets, I did tell the cop I did have it in my wallet and I didn't know where it was.
All right. Small question, probably very obvious. Was the wallet with you?
Yeah, it was like right here next to me.
All right. And did you know that it was methamphetamine?
Yes, I did.
And could you actually see it? Like, was it in a baggie or a bindle?
It was like a little cigarette smoke thing in the zipper part where you would put change.
Okay. And but you knew that you had some there?
Yes.
All right, thank you. And did you have any lawful reason in your mind to possess it? Ms. Carey, do you believe the defendant provided on a factual basis?
I do.
Are you aware of any other promises, threats, or inducements?
No.
The court's compliance with Michigan Rule 6.302.
Yes, sir.
Mr. Burdette, do you agree with all that?
Yes, I do, Your Honor.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for count one. Therefore, the defendant is found guilty of count one. Now we're going to turn to the question of bond. Unlike our other case here this morning, there was a written motion filed for the defense to adjust, asking the court to adjust it to a personal recognizance bond with the understanding that she will be placed at the DOT program. That's DOT Caring Centers, Inc., which is in Freeland, Michigan. Anything further to argue, Mr. Burdette, on that point?
No, Your Honor. No.
I'm sorry, you said no.
But, no, I guess just briefly, I gave the prosecutor a copy of the letter from DOT, which scheduled her intake on July 28th.
All right, thank you. Ms. Carey, any further response or argument? My plan is to release her on July 28th,
Correctly.
directly to the program.
Yeah, as long as that's the plan, the people don't oppose that.
All right, the court will modify the defendant's bond as follows. Beginning on July 28th, the bond will be modified to a personal recognizance bond with the understanding that she must go, enter the DOT Caring Centers, Inc. rehab program in Freeland, Michigan. She will be transported by WEX Express to that program from the jail. She must participate successfully with the program. If she leaves the program unsuccessfully, either on her own or is terminated from the program, she must report back to the jail. Now, Ms. Southwick, that means you'll probably get out of jail in the next couple of days, and you have the right to be physically present in the courtroom for sentencing. We're still going to appear here for sentencing in about a month. I would rather leave you in the program so you don't miss a day of program. You have you have the right to be physically present in the courtroom whenever there's a sentence hearing. You waive sentencing and allow us to have you just appear via Zoom or computer?
Yeah.
All right. Any objection to that, Mr. Burdette?
No, sir.
Any concern, Ms. Carey?
Not that, Your Honor, I would again ask for the signing for release.
Yep, I'm gonna get there. Thank you. You're also gonna have to sign a release. Now, when you're in a program like this, it's private. Nobody gets to know. However, I need to know that's where you're at. So you're going to sign a release that allows the Department of Corrections and Community Corrections to know that you're there. They're not going to be able to invade your privacy. So whenever you're talking to counselors, all that stuff, that's all private. You're just allowing us to make a phone call to find out that you're actually there. Okay? Plus, we have to have a pre-sentence investigation report prepared by a member of the Department of Corrections. And that involves you. You're gonna get a packet here in a moment. You're gonna complete it and turn it in. And I encourage you to get it done before the 28th. And they're gonna schedule an interview with you. That's why they need to be able to call you at the program. All right? And Mr. Burdette, you have the right to have him present, which is generally gonna be via Zoom, at the meeting. Okay, Ms. Southwick.
Mhm.
And then Mr. Burdette, once he gets this report, which is generally in about 2 weeks prior to sentencing, he's gonna have to call you as well to go over it with you to make sure there's no need for corrections. Okay, do you understand? All right. Now, Ms. Southwick, if you leave the program, if you test positive, if they kick you out of the program, I expect you to come back to jail. Now, if you don't, I guarantee you I will issue a bench warrant. So if you leave a program, that ain't good. If I have to issue a bench warrant for sentencing, that isn't good either. Which means you wouldn't most likely get your 7411, okay? Now, I'm really trying to talk, not negatively, but positively to say, we're all cheering for Emily to do everything right,
I
okay?
appreciate that. Thank you.
Thank you very much. Anything further today, Ms. Carey?
No, thank you.
How about you, Mr. Burdette?
No, sir.
Ms. Southwick, any questions?
No.
All right. Good luck to you. We're adjourned. Our next case is People of the State of Michigan versus Brendan Carter. This is file 25-14044FH. Appearances, please.
Nick Carnes on behalf of the people.
Robert Hertel from Mr. Carter, who joins me at the table.
Thank you. You may be seated. We are here today for a final pretrial conference. The council and I met briefly in chambers. They informed me that there would be a pretrial agreement resolution in this case. As I understand it, the defendant is to enter a plea of guilty to an added count 2 and an added count 3, both involving contributing to the delinquency of a minor involving the delivery of alcohol. Is that correct?
That's correct.
And then count 1 will be dismissed.
Yes, Your Honor.
Thank you. All right. Oh, also, there is a killer brew that the defendant would be placed on the Homeless Youthful Training Act program. Right?
That's correct.
All right. Mr. Hartel?
That is accurate.
All right. Thank you very much. Let's make sure I know what the statute is for the contributing.
Yes, Your Honor, that is MCL 750.145. And that is a 90-day misdemeanor with a fine of up to $500 per MCL 750.504.
All right, thank you.
Your Honor, there's one additional thing. We did discuss dismissing the show cause, and I've checked with community corrections, and I'm going to dismiss the show cause.
Thank you very much. All right. Mr. Carter, is that how you want to resolve today's file? Make sure you're speaking up. Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth? You may lower your hand. All right, sir, as we begin, I will highlight for you, while I know it was only 5 seconds ago, you took an oath to tell me the truth, which means everything must be the truth. Here's why I say that. Typically in pleas, not typically, sometimes in pleas, especially in pleas somewhat like this, somebody is reluctant to say they did X. If there's any reluctancy, then we're done and we're just going to trial. Okay. I want just to highlight for you how important it is that you're honest and open. Now, sir, you are currently charged on a felony information with a single of criminal sexual conduct in the 4th degree on a person between 13 through 15 under the age of 16. Now, 4th degree is just a, sorry, not just, is a allegation of contact, right? It doesn't involve penetration. It basically involves contact or touching of some place that basically is covered by a bikini, right? That's a high court misdemeanor punishable by up to 2 years and or $500 in fines, plus mandatory HIV and STD testing, plus registering as a sex offender on the Tier 2 underneath the Sex Offender Registration Act. Told that count will be dismissed if you enter a plea of guilty to, and I accept that guilty plea, an added count 2 and an added count 3 of contributing to the delinquency of a minor toward the delivery of alcohol. Right? What I'm told is to 2 individuals who are under the age of 21. Each of those are a misdemeanor punishable by up to 90 days and or up to $500. Any sentence those would run concurrently, which means if I gave you 60 days for each charge, you'd only have to serve 60 days versus consecutive, which means you'd have to serve 120 days. However, there is a killer rule agreement regarding sentencing, which means you and the prosecutor agree that at the time of sentencing, I will place you on the Homeless Youthful Training Act program. Then if I don't, you have the right to withdraw your plea. The Homeless Youthful Training Act program is only available to people who will enter a conviction who are under the age of 26. How old are you? 22? 19, sorry, thank you. And they can't have any disqualifying prior convictions. Do you have any prior criminal convictions? No. Now, if you're placed on the HYTA and you complete that program, which could be up to 3 years, actually no, because it's it would be to a misdemeanor. If you complete it, the charges will be dismissed. Do you understand? And is that what you wish to do today? Now, by entering a plea of guilty to the added counts 2 and 3, and if I accept that plea, you're not going to have a trial and you're going to be waiving certain rights. I'm holding up a piece of paper that at the top says advice of rights, and the bottom has your signature. Pointing to it here, is that your signature? Did you read through these rights before signing? Did you understand what you read? Even more importantly, do you understand that by pleading guilty, if I accept that plea, you will be forever waiving those rights as they apply to this case? Additionally, you'll be given up the right to claim the plea was a result of any promise, threat, or inducement not told to the court today on the record, or that the plea was not of your own free choice. Are you entering the plea of your own free choice? I didn't hear you. Is someone forcing you to plead, or are you making your own choice? All right. Had there been any other promises, threats, inducements to force or get you to do it? All right. So, has anyone promised you exactly what the sentence will be? I know you've got this killer rule agreement, but I don't know if I'm going to go along with it because I'm going to wait till the sentencing date to make my decision. So has anyone made any promises to you as to exactly what I'm going to do? Good. As to added counts 2 and 3, how do you plead? Guilty? You've got to speak up. I can barely hear you, and I know I'm a bit older, but if I can't hear you, I guarantee the woman in front of me can't hear you. Guilty. Thank you. All right. Before the court can accept that plea, I need you to tell me what you did that makes you guilty. Turn your attention to March 15th of 2025 in Clam Lake Township here in Westford County. What happened? You gotta speak up, I'm telling you. I don't know how many times I gotta tell a person to speak up, but it's apparently a lot. I knew it was gonna be, I could tell it was gonna be a lot with you. That's why I said it. So on that date, let's do this. Where were you?
In Clam Lake Township at houses.
At a house at where some other people were, is that right?
Yes.
And did you provide alcoholic beverages that you knew were to be alcoholic beverages to 2 people who were under the age of 21? And did you know that those 2 people were under the age of 21? Who were those 2 people? Do you have any, were they 2 young women, 2 boys, men? I don't know, whatever. Tell me. A couple young women?
2 young women.
All right, and you knew they were under 21 and you knew you couldn't supply them alcohol, but you still did it. Thank you. Mr. Carnes, I believe you provided a factual basis.
Yes, sir.
Are you aware of any other promises, threats, and inducements?
No, Your Honor.
I believe the court's compliance with Court Rule 6.302.
Yes, sir.
Mr. Hartel, do you concur with all 3?
I do.
The court agrees and finds the defendant's plea today is made freely, felony, and voluntarily. The court further finds that the testimony from the defendant under oath on the record satisfies the elements. Therefore, the defendant is found guilty of count 2 and count 3. Count 1 will be dismissed at the time of sentencing. Sentencing is going to be in about 4 to 5 weeks. So your sentencing is in this courtroom every Monday morning. Between now and then, you're going to have to get a pre-sentence investigation report done by an agent from Michigan Department of Corrections. That report will require you to fill out a packet, answer all the questions, and turn it back in. You'll also be subject to an interview with an agent from that office. You have the right to have your attorney present with you at that interview. You also have the right to go over it, make any or request corrections or make objections to the content, which means when Mr. Hartel gets it in about 10 days and 2 weeks before sentencing, he's going to have to meet you and go over it with you. So you need to make sure you stay in contact with him. Do you understand?
Yes, sir.
So when you leave this courtroom, you are going to go down to the probation and parole office. They are on the 1st floor. If you take the elevator, I'll first question why a young person isn't using the steps. A little bit of finger. But if you were to take the elevator, go all the way down, step out, do a sharp button hook to the right, straight down the little ramp is a door. Go through the door. Second doorway on your left is the probation or parole office. Tell them you're here, you need a packet, a PSI packet, okay? If you have any questions, Mr. Hartel's there. If you just go to that hallway and say, hey, Judge Elmore sent me down, they're gonna tell you where to go. Got it? Any questions? No. Any further, Mr. Hartel?
No, thank you, Your Honor.
Any objection to continuation of bond?
No, Your Honor.
Bond continues. We are adjourned. Our next case this morning is People of the State of Michigan versus Stefan Perez. This is file number 25-14045-FH. Appearances, please.
Nick Carnes on behalf of the people. Judge Slocum on behalf of Mr. Perez, who is also present.
Thank you.
May I approach, Your Honor?
You may. Thanks. Thanks. All right. Final pretrial conference day. I met with the attorneys earlier in chamber. They told me they anticipate a pretrial agreement. I won't steal your thunder this time, Mr. Carnes. Tell me what the agreement is.
Thank you, Your Honor. It's my understanding that Mr. Perez will plead guilty to count one, and the people will dismiss the habitual offender second offense notice. There is also an understanding that so long as Mr. Perez remains compliant on bond, I'm going to be recommending the mandatory minimum jail sentence of 30 days.
Mr. Slocum?
That is a full statement of the agreement, Your Honor. There's nothing more to it.
Mr. Perez, is that how you wish to resolve?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony you are about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
You may lower your hand. All right, make sure everything you tell me is the truth, because I will always believe it as such. Okay. Turning your attention back to March 18th of this year. Were you on probation, parole, or bond?
No, sir.
And you are currently charged on a felony information with a single offense. That count is for operating while intoxicated as a third offense. That is a felony punishable by a minimum of $500 to a maximum of $5,000, and then either a minimum of 1 year to a maximum of 5 years in prison, or in the alternative, a combination of a period of probation with a minimum of 30 days to a maximum of 1 year in the county jail, of which at least 48 hours must be served consecutively, and or a minimum of 60 to a maximum of 180 days of community service, plus cost for prosecution, reimbursement for any emergency responses, as well as mandatory vehicle immobilization of at least 1 year to a maximum of up to 3 years. Now, you are also charged as a second habitual felony offender. That basically takes that punishment and adds on to it a half. So, for instance, that would mean that the maximum punishment could go from up to 5 years to up to 7.5 years in prison. Do you understand?
Yes, sir.
Now, I'm told today that you're going to enter a plea of guilty to count one. And if I accept that plea, the prosecutor agrees to two things. First, that he will dismiss the habitual offender. Second. Third, he will support or request the court to only sentence you up to the mandatory minimum of the 30 days in jail, along with probation. Do you understand? Now, the word support is different than other words you probably heard me use this morning from the back of the courtroom, such as Killebrew and Cobbs. Well, this isn't a Killebrew agreement or a Cobbs agreement. If we come back for sentencing and I sentence you, say, to, I'm just going to pull out a random number because it makes it easy, 6 months, which is 180 days. You don't have the right to withdraw your plea. It's not a Killebrew agreement. But he's agreeing that if you remain compliant on bond, he's only going to ask me to give you the 30 days and the probation. Do you understand?
Yes, sir.
All right. Well, in addition to this, the Secretary of State may take sanctions against your license. That is decided by the Secretary of State and not handled by this court. Do you understand?
Yes, sir.
By entering a plea of guilty, you're not going to have a trial of any kind. Does that make sense?
Yes.
I'm holding up this piece of paper for you to see, and at the top it says advice of rights. At the bottom it appears to have your signature. Is that your signature?
Yes, sir.
Did you read through these rights before signing?
Yes, sir.
Did you understand the rights that you read?
Yes, sir.
Even more importantly, you understand that if you plead guilty and I accept that plea, you will be forever waiving these rights as it applies to this particular case.
Yes, sir.
Additionally, you'll be given up the right to come back and say, Judge, I forgot to tell you there was some other promise, threat, or inducement. Have there been any other promises, threats, or inducements to force or compel you to plead guilty?
No, sir.
Are you entering the plea of your own free choice?
Yes.
And while I have talked about the potential of sentencing, I trust that Mr. Slocum has talked to you about Michigan sentencing guidelines and tried to give you an idea or estimate of those guidelines and an idea or estimate as to what he thinks I would do for sentencing.
Yes.
The question I have for you, though, is anyone promised you what I will do? You still wish to enter the plea?
Yes, sir.
As to count one, operating a vehicle while intoxicated as a third offense. How do you plead? Before I can accept that plea, I need you to tell me what you did that makes you guilty of the offense. So turning your attention back to March 18th of 2025, up in the village of Mesick here in Wexford County. Did you operate a vehicle?
Yes, sir.
Where did you operate that vehicle?
On the roadway.
And was it 115? I know that runs through Mesick.
I was at a friend's house traveling back to my house.
Okay, and that was on a roadway open to the public.
Yes.
And at that time when you were operating the vehicle, had you consumed some alcohol?
Yes, sir.
And Mr. Carnes, do we have an intoxilizer report?
Your Honor, we have blood
Blood?
results. It comes back at a 0.154. The people would stipulate to that.
Mr. Slocum, does the defense stipulate to that result for the taking of the plea and sentencing?
I do, Your Honor.
And this did not result in any accident, correct? Either involving somebody else or even your own vehicle? And is it also true, Mr. Perez, that you were previously convicted back on November 3rd, 2009 in the 13th Circuit Court in Grand Traverse County for operating while intoxicated?
Yes.
And is it also true that you were convicted again of operating while intoxicated or impaired as a second offense on September 19th, 2017 here in the 84th District in Wexford County?
Yes, sir.
Mr. Carnes, I believe he's provided a factual basis.
Yes, Your Honor.
Are you aware of any other promises to inducements?
No, Your Honor.
Do you believe the court's compliance with the court rules?
Yes, Your Honor.
Mr. Slocum, do you agree or concur with all three?
I do.
The court agrees and finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds that with the testimony provided by the defendant under oath on the record, in addition to the stipulated the stipulated blood draw, the defendant is found guilty of operating while intoxicated as a third offense, also based upon the prior convictions in the two courts mentioned earlier. All right, Mr. Perez, we're going to set up for sentencing. That's going to be in about 4 to 5 weeks. We'll do them on Monday mornings in this court. Between now and then, an agent from the Michigan Department of Corrections must prepare a pre-sentence investigation report. That report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide in the preparation of that report, and it will also make a recommendation as a sentence and include a scoring of the guidelines. Please keep in mind that the guidelines are not mandatory and neither is the recommendation. There are 3 steps involved. You're going to leave the courtroom, go down the stairs or use the elevator, step out, do a sharp button hook right to the west, and there will be a hallway. You probably have already been doing tests at community corrections. Is that right?
Yes, sir.
If you were to stand in front of the community corrections window and do an about face, you take 3 steps forward, you can walk into the Department of Corrections, okay? They're going to give you a packet, you're going to complete it, turn it back in. You're going to be subject to an interview, and you have the right to have your attorney present during the time of that interview. Also, Mr. Slocum's going to need to make sure he gets a hold of you to go over this PSI, because each side has the right to come back to this court and request corrections or make objections to the contents. We must make sure it is complete and accurate before the court uses it to establish a sentence. Do you understand?
Yes, sir.
Any questions about what we have done today?
No, sir.
Mr. Barnes, any objection to the continuation of bond?
No, Your Honor.
Anything further from you, Mr. Slocum?
No, Your Honor.
Thank you very much, Mr. Perez. We'll see you in about a month. Yeah, no, sorry, nothing. That's it. Don't know why I said, we're adjourned. Right. And then there was one. Never mind. Nancy, Elena just said 3 letters we gave together. Right in the middle. All right, so here we go. We need appearances.
People.
Robert Hertel for Mr. Cowley, who is joining me as I speak.
All right. We're here today for a final trial agreement. No, I didn't. Sorry. People of the state of Michigan versus Randy James Cowley, file 25-14076FH. The appearances have been entered. Ms. Joanna Carey is here on behalf of the people. Mr. Robert Hartel from the Public Defender's Office here on behalf of the defendant, and the defendant is here as well. You all may be seated. We're here for a final pre-trial agreement. I met with counsel. They told me there would be a resolution. Ms. Carey, why don't you go ahead and tell me what that agreement is?
It's my understanding the defendant will plead no contest as follows. Count 1 will be dismissed. Will plead no contest to count 2. Plead no contest to count 3. Count 4 will be dismissed. Will plead no contest to count 5. The habitual offender 4th notice will be dismissed. The reason for the no contest plea, I believe, is intoxication.
Mr. Hartel?
That is accurate on all parts, Your Honor.
Thank you. Mr. Cowley, is that how you wish to resolve today's file?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Make sure everything you tell me today is true and accurate. Now, you are currently charged on a piece of paper called a felony information, and it informs you and I that you are charged with 5 counts and a sentencing enhancement. Counts 1 and 2 are both charges of assault, resist, obstruct a police officer. One involves a Deputy Webster, and the other one involving a Sergeant Rowell, Rowell. Each of those are a felony punishable by up to 2 years and or up to $2,000. Ms. Carey, am I correct that this did not occur in a place of confinement? Or did it?
The one on the note did occur at the jail.
All right. So are the people going to request, or do they agree to not request consecutive sentences?
Good. That's it.
All right, so Mr. Cowley, what I need to tell you here is that this offense, again, is, as I mentioned, is punishable by up to 2 years and or $2,000 plus consecutive sentence may be imposed if the assault committed was committed in a place of confinement. So if you assaulted a corrections officer or an officer taking you into the jail, any sentence could, within my discretion, run consecutive to any other offense. Prosecution agrees that they are not going to ask for it to run consecutive. Okay? Was anybody severely hurt in this, Mr. Hartel?
Not that I've read the report, no, Your Honor.
All right. So, thank you. So, there's also a 4th habitual felony offender sentencing enhancement. That means that counts 1 and 2 could be increased from a potential of up to 2 years up to a maximum of 15 years. However, I'm told that you're going to plead no contest to count 2. Count 1 will be dismissed, and so will the 4th habitual felony enhancement. It means for count 2, you're facing up to 2 years and or $2,000. I'm also told that you're going to plead no contest to the next count. The next count is a charge of larceny less than $200. In fact, both counts 3 and 4 are the same. Each are a larceny less than $200, for which the maximum punishment is up to 93 days and or up to $500 or 3 times the value of the property, which is ever greater. I'm told that you're going to plead no contest to count 3 and count 4 will be dismissed. I'm also told that you're going to plead no contest to count 5, which is a charge of assault and battery. That is also a misdemeanor punishable by up to 93 days and or up to $500. Is that what you understood you were doing?
Yes, sir.
Now, by entering a plea today, you'll not have a trial of any kind if I accept that plea. Do you understand?
Yes, sir.
I'm holding up this piece of paper for you to see. It was provided to me by your attorney a few minutes ago. At the top, it says advice of rights, and at the bottom appears to have your signature. Is that your signature?
Yes, Your Honor.
Did you read through these rights before signing?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And even more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving these rights as it applies to just this case?
Yes, Your Honor.
Additionally, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me on the record. Have there been any other promises, threats, or inducements to get you to plead guilty that we haven't talked about?
No, Your Honor.
You went to plead to have your own free choice.
Yes, Your Honor.
Now, Mr. Hartel has probably talked to you about the Michigan sentencing guidelines. Try to give you an idea as to what he thinks those guidelines would recommend to the court. And he's also try to give you an idea of what this particular judge will do for sentencing. Now, those are all estimates. Do you understand?
Yes, Your Honor.
None of those are binding upon me. You understand? And so has anyone tried to promise you what I'm going to exactly do?
No, Your Honor.
Good, because I don't know. All right. Do you still wish to enter the plea of no contest that we talked about earlier?
Yes, Your Honor.
And the reason is, Mr. Hartel, a level of intoxication. Is that correct?
That is correct, Your Honor.
So, Mr. Cowley, is it correct that you don't recall these events because of some level of intoxication?
Yes, Your Honor.
Now, if you enter a no contest plea, it has the same impact as a guilty plea. The difference is instead of requiring you to tell me what happened, I'm going to look at something else. And whatever I look at, the parties give me, well, that's the story. You can't ever come back and say, well, it's not true. You understand?
Yes, Your Honor.
As to count 2, assault, resist, obstruct a police officer, how do you plead?
No contest.
As to count 3, larceny, less than $200. Looks like that involves stealing cigarettes. How do you plead?
No contest.
As to count 5, assault and battery, how do you plead?
No contest, Your Honor.
All right, counsel, what am I going to look at?
County Sheriff. Number 83-2500763.
And we're going to have that marked. Any objection, Mr. Hartel?
None, thank you.
All right, how about also marking the preliminary exam transcript? I have that in the file.
That would be fine.
Now, clerk and court reporter, may I have another exhibit sticker? Mr. Hartel, any objections to People's Exhibits 1 and 2?
None, thank you, Your Honor.
The court here thereby accept People's Exhibits 1 and 2. Number 1 again is that the Wexford County Sheriff Incident Report 83-2500763. Court notes that the date and the jurisdiction are covered within the first few pages of the primary report, and there are multiple supplements attached to the report, including photographs. Okay, Ms. Carey, do you believe these 2 exhibits provide a factual basis to support the taking of the plea?
I do.
As to counts 2, 3, and 5.
I do.
Mr. Hartel, do you agree?
I agree, Your Honor.
Ms. Carey, are you aware of any other promises, threats, or inducements?
No.
Mr. Hartel?
Nor am I, Your Honor.
Ms. Carey, do you believe the court is in compliance with Scroll 6.302?
Yes, sir.
Mr. Hartel?
Yes, Your Honor.
And Ms. Carey, do you believe that the interests of justice based upon the level of intoxication or under the influence allows the court and supports the court, as well as potential civil liability for the assaulted conduct, allows the court to take a no contest plea?
I do.
Mr. Hartel, do you concur?
I do, Your Honor.
The court agrees today and finds the defendant's plea is made freely, knowingly, and voluntarily. The court further finds the testimony provided in the preliminary exam transcript, People's Exhibit number 2, as well as the detailed factual information and the People's Exhibit number 1, Sheriff's Incident Report satisfies the elements. Therefore, the defendant is found guilty of count 2, count 3, and count 5. Count 1 and 4, and the 4th habitual felony offender will be dismissed at the time of sentencing. Mr. Cowley, the case will now be set for sentencing. That will take place in about a month. We do them on Monday mornings. Between now and then, an agent of the Michigan Department of Corrections must prepare a pre-sentence investigation report. That will require you to go downstairs to the probation and parole office, right across the hall from the community corrections office on the first floor. They're going to give you a packet. You're going to complete that packet and turn it back in. They're also going to schedule an interview with you. You have the right to have your attorney present during that interview. Mr. Hartel is going to need to meet with you prior to coming back to court next time to go over that report. Each side has the right to come to this court and request corrections or make objections to the content of the report, as we must make sure that it is complete and accurate before the court establishes a sentence based upon it. Therefore, you must maintain communication with Mr. Hartel. All right. The report will include a description of the offense, description of the pretrial agreement, any statements, information you make or provide on the preparation of the report. It will also include a recommendation on as a sentence and a guideline scoring. Please keep in mind that the scoring, the guidelines, and the recommendation are not mandatory upon the court. However, they are very valuable tools for the court to consider. Do you understand?
Yes, sir.
Any objection to continuation of bond is carried.
Yes, sir.
Anything further from you today, Mr. Hartel?
No, thank you.
Mr. Cowley, I'm going to adjourn in just a moment. Your bond conditions remain in effect. Please note that before you leave the building, you need to stop by that office I told you. Okay?
Yes, sir.
Any questions? One.
On behalf of JP Investments, is Attorney John M. Friedel. Mr. Gale, you may proceed.
Thank you, Your Honor. This is plaintiff's motion in limine to exclude any introduction or reference at trial to a purported lease agreement that was produced by the defendant months into this litigation, only after plaintiff's deposition, and which was never produced in response to discovery or with defendant's initial disclosures. As laid out in our motion, the document is inadmissible as it contains terms that are illegal and void under Michigan law. Despite the unusual, the motion and alternative that was filed by the defendant that's up for hearing today, there's simply no dispute in this case that at the time of the subject incident, plaintiff was a tenant at the defendant's property. And on February 27th, 2023, he tripped and fell due to loose ceramic tile on the front steps of the property. This case was filed under the Michigan landlord-tenant statute, as well as common law premises liability principles. Defendant has now produced this lease agreement, which purports to exculpate the defendant landlord from all liability by claiming that Mr. Curtis offered to repair this front porch and these steps that he fell on in exchange for early occupancy in the residency. But as I've laid out in the motion, first of all, this lease agreement, it's just an unreliable document. The first page of the document has no signature on it. The formatting at the bottom of the document, page 1 of 2, is completely inconsistent with the way page 2 of 2 is written on the second page, and I hope the court saw that in my briefing. Plaintiff unequivocally denied under oath ever agreeing to make repairs to this porch, and he was never shown a copy of this lease agreement at his deposition to even be given an opportunity to respond to it. So the document is just unreliable. And as to the legal reasons why it's invalid and void under Michigan law, under MCL 554.139, a landlord covenants in every single lease agreement to keep the premises and the common areas fit for their intended use and to keep the premises in reasonable repair. I'm not entirely sure what the defendant's response even is to this argument. He seems to raise an issue that drawing a distinction between common areas and the premises. So just to briefly touch on that, this is a single tenant premises. There is no common area. There aren't multiple tenants here. There's only one tenant. So the entire premises is the premises. There's no common area. It's not a shared stairway between multiple tenants. That's how the Allison case defines common areas. And there's no dispute here that the defendant didn't keep the premises in reasonable repair. He claims that this clause in the lease agreement exculpated him from his duty to do so. But these duties are mandatory. They can't be waived, except in a limited situation where a lease is for more than 1 year, which there's no dispute in this case, it was not. As I've laid out in the motion, it also violates the Truth in Renting Act. MCL 554.633 expressly prohibits a lease clause that exculpates a landlord from liability for failure to perform a duty imposed by law. In Califf v. West, the Court of Appeals upheld this in a published decision. Leasehold agreements like the one we have here, where the landlord claims that he has no duty to perform repairs, are illegal. They're void. So the reason we've asked that it be excluded is that it has no relevance, and if it did have any marginal relevance, which we deny, its prejudicial impact would far outweigh the probative value. It would mislead the jury into believing a tenant can waive these statutory protections. It would create unfair prejudice by implying that plaintiff assumed responsibilities for repairs, which he cannot do under the law. And it would confuse the jury and waste time on a clearly void and illegal document. So for all of these reasons, the document's factually untrustworthy. It's void and illegal under Michigan law. It should be excluded from evidence.
Thank you, Mr. Gale. Mr. Friel, your response, sir?
Yeah, Your Honor, I'm going to rely primarily on what we filed because there's a lot of detailed arguments that are being raised here. That ultimately, this is a motion in limine. It's an evidentiary motion to exclude the lease entirely, to prohibit introduction, admissibility, and to prohibit any reference to the lease or its underlying relationship at trial. Mr. Gale, with all due respect, has just argued three different kinds of motions. An unfiled C9 motion that has to do with whether or not certain facts are in dispute, which would enable the court to arrive at conclusions as to whether statutes have been breached or violated. The statutes that are being referred to are contractual in nature and expressly so. They operate to inject terms into a lease, either if they're not adherent in the lease already or if they're missing. That's not a dispute, but that would be a matter for a C9/C10 type of a motion. The other type of motion that's being argued but isn't in the motion is a kind of an implied discovery sanction request. This is a lease that is central to any statutory action about a lease. Technically, the lease should be attached to the pleadings. It's referred to liberally, and to pretend that they don't know that he's there by virtue of the lease is highly disingenuous, and it has substantive effects, and hence our motion to strike. Because if you're denying that there's a lease agreement that's enforceable, then you're a trespasser, and that changes the dynamic of the premises liability part of their case on its head. It eliminates the statutory action. So the reason that our motion to strike in the alternative is so unusual is because in my time as an attorney, I have never seen a landlord-tenant premises liability case where the plaintiff wants to exclude the lease. Now, if the court were to find via some other mechanism, and it would have to be through proofs, either submitted via dispositive motion or at trial, that there are terms that are inappropriate that actually do exculpate the defendant in a way that is violative, the remedy is that they're not enforceable. That's expressly provided for in the statute. You don't just throw, as I've said repeatedly, the baby out with the bathwater. So what we really have is a motion to exclude in its entirety based on lack of relevance, or in the alternative that it's unduly prejudicial, et cetera. To say that this lease is not relevant, it's evidence also of a contract that may be verbal. The lease may not be verbal due to the statute of frauds and other provisions, but it contemplates the defendant's hiring of the plaintiff, who uniquely to this case is represented to be at least a qualified tile contractor who was going to be insured, and he was hiring him to discharge his duty as a landlord. That's not to be confused or conflated with the idea of supplanting your landlord duties or imposing them onto the tenant. That's not what's even being alleged here in the motion or in the lawsuit. So the idea that the lease wasn't attached to the complaint in the first place, if we were to file a C8 motion based on the court rule that requires it, and there's a failure to plead the action without attaching the document upon which the action relies, the answer would almost surely be, well, it's in the mutual possession of the parties. They both signed it. And to have produced the lease that I did without being asked to as a courtesy, because I anticipated it would come up at my client's deposition. This isn't a situation where the plaintiff was confronted at his deposition with the terms of the lease and not given them to review. He was asked general questions relative to which I think his answers could serve as a basis to impeach his credibility later when you look at what he signed. But whatever copy I supplied to Mr. Gale was intended as a courtesy. It was never requested in a request to produce. It was not included in their initial disclosures relative to a lawsuit that relies entirely and circulates around this lease. And to say now that somehow it should be excluded, that's a very harsh remedy for an alleged discovery violation that hasn't even appeared yet in a motion. And certainly I'd be happy to go into that if Mr. Gale wanted to file such a motion. We get into the details, and I don't think that that would be an appropriate remedy at all. We don't waive notice to anything other than an evidentiary motion today on whether or not the lease is relevant. And I think for 5 or 6 different ways, 2 or 3 of which are highly unique to this case, it would be ridiculous to say that this is not relevant. If it's not relevant, then it's not material or pertinent under the 2.115B standard, which is limited just to pleadings, hence the counter motion, so to speak. So that's all I have, but I'd be happy to answer any questions if there are any.
Mr. Friel, if I'm correct on this, the initial filing in this case, and Mr. Gale can chime in as well, but my initial understanding is when we had the first pretrial on this, you, Mr. Friel, had given Mr. Gale a heads up that the wrong defendant was being sued. Is that correct?
That's correct. The owner of the property is the LLC, and that's the insurance.
Hence, obviously, the pleadings were amended, and now we're here today. Mr. Gale, any other response, your rebuttal argument to this, please?
Yeah, just to briefly respond, this is not a motion seeking discovery sanctions. This motion is about the main issue that the defendant hasn't even responded to. It's about the lease terms being illegal under Michigan law, and therefore it would confuse the jury, it would mislead them, it would waste trial time by allowing this document to be admitted at the time of trial. The defendant hasn't explained in any way in his briefing or an oral argument how these terms are legal. There's just been a number of, it sounds like, procedural issues raised, stating that it's a discovery issue. No, the terms are illegal. They shouldn't be shown to the jury. It will make them believe that this was a valid term in a contract in this lease agreement, which it's not. And as I've stated in response to the motion in the alternative, if the court finds it too, overly broad to strike the whole lease, then just simply strike the terms of the lease agreement that are illegal, basically where the landlord says he has no duty to repair the property. That clearly violates the law. Any way the defendant tries to spin it by stating the tenant has to do it and not him, that would violate the law. I haven't heard any response to that. So that's my rebuttal.
Mr. Gale, wasn't it alleged that basically that was part of the benefit of the bargain in the lease? That, hey, look, I really don't want to lease these premises because, for instance, look at these steps. They're not safe. I'm not ready to lease. I'm not ready to lease. But then there's a meeting of the minds between the two where, hey, look, I specialize in this field. I do this type of work. I'd be glad to do that. And by doing so, would you let me into as a leasehold, as an individual leasing the property? How does that square with that?
Fair enough, Your Honor. And that is what the defendant alleges. My client, of course, disputes that. But here, the express language of MCL 554.139(2) says the parties to a lease or license may modify the obligations imposed by the section where the lease or license has a current term of at least 1 year. We don't have that here. So they have no right, even if there was a meeting of the minds, they have no right to modify the obligations. And the third section of that same statute, it says the section shall be liberally construed. The privilege of a prospective lessee to inspect the premises shall not defeat his right to have the benefit of the covenants established herein. So unless the lease was for more than a year, there can't be a meeting of the minds to waive these rights under the statute.
Your Honor, how can you even argue any of that or even know any of that without the lease as evidence itself? They're arguing that there's a provision that's not enforceable, and I think they're confusing the contract to hire somebody to fulfill the landlord duty by the landlord with for example, the hold harmless provision. That may arguably be exculpatory. Then either it's blocked out or there's a jury instruction. And one of the reasons that we don't really respond to each one of these alleged violations is, first of all, they're not supported. It's not C9, but more important to this motion, the remedy, if there's any, at the time of trial, is to give a jury instruction. You don't just, like I say, throw the baby out with the bathwater. This is a classic example of cutting off your nose to spite your face, because you're saying, I'm going to take the thing that gives me a cause of action, either by tort or by contract, and I'm throwing it right out. Now what? What are you going to do about that? Well, I'm going to move for a directed verdict as soon as you sit down after you make your opening statement. This is really basic. The jury instruction can be fashioned. If a jury instruction can't be fashioned, we block that part of the lease out. And they're instructed not to infer anything from the fact that something's been blocked out. But you don't just take the whole lease and say, we're out of here. And by the way, now I'm a trespasser because I can't prove that I had any right to possess the premises.
And I've said, if the court finds the defendant's arguments persuasive, then simply strike those portions of the lease that are illegal.
Well, as far as the court's concerned, obviously I read the motion. I read Caleb BW, read all the statutes, Allison, I read all the cases, but I think we need an evidentiary hearing here, because it's even disputed that the first page of the lease was part of any type of lease, as I understand it. So as a result, the court is going to reserve ruling on this matter, have the parties present their proofs and evidence in the form of whether it be Mr. Curtis or the registered agent of JPN Investments come in, and I think we're going to have to pick through this a little bit more. And Mr. Gale, you may supplement your motion as well. I'm not telling you that Mr. Friel is right, that it is a C9 or C8, whatever it may be. But what I'd like to do is get the testimony of these individuals in court, and then we can make a decision based upon that.
Understood, Your Honor.
And when do you think we could hold that hearing, counsel? Well, why don't you just renotice it when you're ready? I think that might be the better course of action.
Your Honor, we had also, just so that you're aware, we had also called your office about scheduling a dispositive motion, and we wanted to make sure that it was going to be an available date that was still compliant. And I haven't discussed that with Mr. Gale yet, but it might be worthwhile for us to coordinate all of this, because that's going to be of an evidentiary nature as well. So contrary to what you might infer from reading the documents, Mr. Gale and I get along fairly well, and we've been able to work out all of these types of issues, and I'm confident we'll be able to here. But we'll come to some kind of a consensus and then approach the court. That's what I would propose, if he's in agreement.
Any objection to that, Mr. Gale?
No, that works for me as well.
Wonderful. I appreciate that, because I've just been advised by my court administrator, trial scheduled for September 9 already.
That's correct.
Yep.
And 24 case. So, all right, I'll allow counsel to kind of coordinate that with either Ms. Hatch or Ms. McNames, and we will see you gentlemen down the road. Thank you for your time this morning. Have a wonderful weekend.
Thank you.
Thanks, Your Honor.
Thank you. Awesome.
The state of Ohio versus Scott. Thank you, Your Honor. We're here on the matter of the state of Ohio versus Scott Burns, case number 25 CR 000881. The defendant is present in open court with their attorney, John Patika. We are set today for a plea by information, where the defendant will be pleading to abusing harmful intoxicants, a felony of the 5th degree in violation of 2925.31. The state would request a pre-sentence report and a drug and alcohol evaluation prior sentencing.
Tika?
Good morning, Your Honor. I've discussed this matter with Mr. Burns. I anticipate a knowing, voluntary, and intelligent guilty plea will be forthcoming.
All right, Mr. Burns, how old are you?
I am 41 years old, Your Honor.
How far did you go through school?
I made it to 12th grade, but then I completed my GED.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
No, Your Honor.
Have you ever been diagnosed with or treated for any mental illness?
Yes, Your Honor.
What have you been diagnosed with?
Depression, anxiety, and PTSD.
Are you being treated for any of those?
I am supposed to be receiving medication, but I have not received it here.
Did you get a copy of the information that was filed in this case?
Yes, Your Honor.
And did you review it with your attorney?
Yes, Your Honor.
You understand you have a right to have your case presented to the grand jury for them to decide whether or not to indict. Do you understand that?
Yes, Your Honor.
And do you want to waive that right?
Yes, Your Honor.
All right.
I sign here.
Close the top, right?
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, let me know. If you want to talk to Mr. Fatika some more, let me know, and I'll give you more time. Do you understand that?
Yes, Your Honor.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
Do you still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Your Honor.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I sentence you to prison, to jail, or to community control.
Yes, Your Honor.
Abusing harmful intoxicants is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
Are you currently on post-release control to the parole authority?
No, Your Honor.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, the parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If that violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, Your Honor.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, Your Honor.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk to Mr. Fatika before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right. Mr. Knopf, if the case went to trial, what would the evidence show?
Your Honor, had the case proceeded to trial, the state would have shown that on or about May 7th, 2025 in Lake County, Ohio, police responded to 84 Lumber for a report of a male laying in the woods about 100 yards away from the facility. That male was identified as Scott Burns. Police approached the male, and the male stated that he was waiting for his lift to arrive and inhaling duster while he was waiting. The defendant also has a prior drug abuse offense out of Cuyahoga County, case number CR 23679270A, which enhances this to a felony of the 5th degree.
All right, Mr. Fatika, anything to add to those facts?
No, thank you, Your Honor.
Mr. Burns, did you hear what Mr. Knopf said, that the facts would show if the case went to trial?
Yes, Your Honor.
Are those facts true?
Yes, Your Honor.
What is your plea to abusing harmful intoxicants, a felony 5?
Guilty, Your Honor.
And what is your plea to the forfeiture specification?
Yes, Your Honor. Guilty.
All right, Mr. Fatika.
Here. Oh, sorry. Ready to talk about that?
First things first.
I got you.
Okay, this is the original of that, okay. You scratch this out because this isn't a felony, the first and second degree. Sign that, please.
Your Honor, for the record, I have witnessed the defendant and defense counsel sign the written plea of guilty. I've now signed it myself, and I'm giving it back to Mr. Fatika.
Mr. Burns, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
Do you want me to accept your written plea of guilty?
Yes, Your Honor.
Accept the written plea of guilty. Defendant was present. Mr. Fatika advised of all of his rights, been a knowing, intelligent, voluntary waiver. Understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept his plea of guilty and find him guilty of abusing harmful intoxicants, a felony 5, and the specification. I refer this for a pre-sentence report and a psychological evaluation. Sentencing will be August 28, 8:30 a.m. Mr. Fatika?
Your Honor, we would ask the court to consider an OR bond. Mr. Burns entered a plea last month or the month before in Cuyahoga County Common Pleas Court, was sentenced to Matt Talbot residential treatment. He has a Cuyahoga County holder, would take him from here to there. My understanding is Matt Talbot is a locked facility. We would ask you to consider that. I'd ask for the opportunity to submit a written motion in support. Have you considered it at the appropriate time?
All right, yeah, file the motion and I'll take a look at it. Anything else, Mr. Knopf?
No, Your Honor.
Anything else, Mr. Fatika?
No, thank you.
Okay. All right.
Concrete, I saw concrete, add-ons, new builds.
How much do you
roofing.
make a month?
It just depends on the month.
Well, give me a range. What's a low and what's a high?
I would say anywhere from, let's say, 1 to 10, depending on the month.
1 to 10 what?
1,000.
Okay, I'm not sure he qualifies for assigned counsel.
Understood.
I'm gonna put that it's requested and I'm gonna put that it's granted, conditioned upon defendant proving he qualifies. So therefore, there's no gap, okay? Continue with the, we're gonna waive the formal reading, please not guilty. His request for assigned counsel is conditionally granted so long as he qualifies, okay? So continuing on, please.
My understanding, he's not on probation to any other courts.
I think he just finished probation
Is
out of
what he-
another court for a previous
Understood.
alcohol. Yeah,
The
just,
underlying, obviously, charge here. He said, there's statements to me that probation has since been terminated. No other open matters to speak of. He did appear here timely this morning. As far as a monetary amount would go, if he would consider a personal bond, I did explain to him that other conditions will follow. And certainly we don't take a position in that regard. I would leave that to your discretion.
yeah, the court is setting a $10,000 personal bond. I have concerns with this gentleman who had a prior very so close in time. And, he had to go through the difficult process of another criminal matter and being on probation. And then within months of coming off probation, we have this alleged incident. So do you have anything about him addressing sobriety, going to AA? What kind of testing did he have in that probation? I mean, I'm very concerned. And I would
Best
like
to my
to
knowledge,
address
I don't believe that he violated that probation. Again, without having access to that file. Just given the timing of this, I can't exactly speak to any thing currently taking, but for his statements that he's willing to abide by whatever you feel is appropriate. We had a long conversation about the testing regimen, what's going to be asked of him. I think if you give him that opportunity, that he can demonstrate to the court that certainly is willing to abide by whatever conditions you feel are appropriate.
Okay, the court is setting a $10,000 personal bond with the following conditions. You have to personally appear for an exam, arraignment, trial, or sentencing. You have to abide by any judgment entered in this case, surrender to serve any sentence imposed. You shall not leave the state of Michigan without permission of the court. You shall not commit any crime while released. You shall immediately notify the court in writing of any change of address from Coachwood Circle and or the telephone number ending in 5738. You are not to use alcohol, marijuana, or any other illegal controlled substance. You shall have an alcohol tether through pretrial services, and you shall drug test 1 time per month through pretrial services. Defendant must contact pretrial services or tether, and tether must be in place by Tuesday. What's July 29th? July 29th, 2025 at 3:00 p.m.
Okay, sounds good.
We'll set this matter. What's the name? Do we know who 248 is yet? It's probably Oh, he's probably on twice. Okay. So, all right. We held the arraignment, consent to Zoom. I've concerned. Who's not muted? Did I? Okay, am I? All right, we conduct the arraignment, consent to Zoom. I've confirmed the address and the phone number. I have an email address. Defendant waives a formal reading, which the court will do based upon the representations and statement of defendant. Defendant pleads not guilty, and not guilty plea shall enter. His request for assigned counsel is granted so long as he financially qualifies. He'll have to provide documentation for same. The bond is $10,000 personal with conditions. The standard court rule conditions shall apply. Additionally, you shall not drive without a valid license. I think you had a restricted license. So you shall not drive without a valid license or permit. Okay. You are not to use alcohol, marijuana, or any other legal controlled substance. You shall have an alcohol tether in place through pretrial services. It must be on your person by Tuesday, July 29th, 2025 at 3 p.m. Do you have a phone number, pen and paper, sir?
Yeah.
Okay, your phone number to contact for pretrial services is 248-451-2316, 248-451-2316. It takes one business day for pretrial services to get a file from our court to pretrial services. So if you contact them today, they will not know who you are. The earliest you can contact them is Monday. That's why you're given until Tuesday, July 29th, 2025 to get the tether. However, the order to not drink and or use marijuana or any other illegal controlled substance starts at this minute. We're going to set this matter for a pretrial. You have Judge Meineke. The notice to appear will be sent to Coach Wood. You'll have assigned counsel if you qualify. If you don't qualify, you'll have to retain counsel. Counsel, is there anything further requested or required on behalf of this gentleman's case?
No, Julian, I'm going to send you a form by email that you can use to confirm the financial situation. Just make sure you get that back to me as soon as possible.
Okay.
All right. Thank you. You may leave the Zoom.
Thank you
so much.
Patrick, I don't think I have anyone available for you, but I'm going to call the informals.
That's fine. I'll hang tight. If I sign off, just give me a shout if you
Okay,
need me.
thank you. SP 4544185. This is the state of Michigan versus Richard Nazem Sams. Mr. Sams, I know that you can hear me. You've called the clerk. I've gotten a message sent to the court that you're having technical difficulties and that you can hear me, but I can't hear you. So the date and time was set for your informal hearing at 10:01. It is now 10:27. You've been here since 8 o'clock or 8:30. The defendant has appeared. The trooper has failed to appear. This ticket is dismissed without prejudice. Okay? There's no money due at this time. And Mr. Sams, you may leave the Zoom. All right, we're going to call Vivian your case. Unmute yourself. Calling two cases, SP 453-5527 and 5527A. This is the state of Michigan against defendant Donald P. Schneider, whose preferred name is Vivian Schneider. Please unmute yourself. Please state your name.
Hello.
Hello.
Vivian-
Say your legal
Vivian-
name and your preferred name.
My legal name is Vivian Anderson Schneider.
Okay.
You have me as Donald P. Schneider in this matter.
Okay. So you have appeared. The officer has failed to appear. So this matter was set for 10:01. It's now 10:29. So both cases are dismissed without prejudice. Any objection?
Oh, no. Thank you.
Okay, no objection. You may leave the Zoom.
Thank you very much. Have a good day.
You too. Take care. Be well.
I will. That's it. Done.
Calling the case of SP 4544235. This is the state of Michigan versus Corey Edward Casaban. Your appearance, please. That means state your legal name, sir.
Good morning, Your Honor. My name is Corey Edward Gassman.
Okay, this is the date and time set for your informal hearing. This was set for 10:30. It's now 10:01. The officer has failed to appear. This ticket will be dismissed without prejudice. Any objection, sir?
No, Your Honor.
Okay, no objection. It's dismissed. No monies due at this time. You may leave the Zoom. Thank you for your patience.
Of course. You have a good day, Your Honor.
Thank you. Take care. Be well. Did we just have 2 arraignments? Patrick, did you just do 2 arraignments? That's it? I'm gonna FTA these, huh? What's today? 25.
Was talking to myself. I'm on mute.
But that's okay.
No,
The other ones we only had 2 cases for you, huh?
I only had 4 on my end. One had retained.
Oh, okay. So, right. So, I mean, you only arraigned 2, right?
Yeah.
Patrick, I just read about a trial that you had in the little Oakland County Latches.
Oh yeah.
Did you have a trial?
I'm guessing what
It
month?
listed your name. Let's see, if this is July, maybe it was April or May or June.
Okay. Yeah, I've tried. I've tried probably 3 cases in the last 3 months.
You're busy. And I said, I know that guy. He comes to my. All right.
Thank you for that.
Yeah, I saw you. Saw your name in lights. All right. Well, thank you for appearing today. I appreciate all your help.
Yeah, you as well. I think I see you in two Fridays.
Oh, okay. So I just did the other ones, FTA.
Awesome.
All right. Thank you. Take
You
care.
as well. See ya.
But other than that, I don't have a legal objection.
Okay, and I don't know that we're gonna find it in the transcript right now, and it's not a transcript, it's a draft. But Mr. Abate did say, I'm starting it at, I'm making the numbers up, 6:21, and I'm stopping it at, so we should endeavor to start and stop around the same time. The start is less of an issue because what it is Mr. Dennis singing to himself in the interview room until Stancil comes in. So if it's 2 seconds before, they get more of his lyrics. We just need to make sure it stops when he says lawyer and Stancil confirms that, because Stancil didn't really stop interacting with him after he said lawyer, and they need to not hear that part. But I think it's pretty clear when that begins. Okay. Can you all tee it up, please?
Turn this off. Does this help eliminate it?
Ah, right. Maybe that'll make a difference.
They stop.
Correct. And I wanted this one. You said that they can't. You can speak. You can't pick and choose.
You can pick and choose what they saying when he had to come down and release me because I didn't admit to what he said I said.
The fact that you are not really.
Are you? You're working on it. Okay.
They have to get that you do act your charge. The fact that how do you show that in your issue? Not go either.
Then it was showed that I was released, because I was released. And then his authority overruled his judgment and said that it was a mere question and not an answer. That's what the jury need to see.
One does not fall.
So why
can't
can't
release you because supervisors because journalists they call APD. They want him to get to end a statement before picking up.
All right. I need you guys to stop talking for a sec so we can see what this audio is like.
I mean, so this is where I give you credit, right? Yeah. Clearly, you got to prove that, right? And I get it. My whole thing is, I want to make sure.
Can you pause it for a sec? So I think maybe I have something that will adjust the volume. You don't have a way of other than on your device. Okay, let me see what I can find here.
He spoke in my court, but he straight into my computer. Now, would it play through Zoom? It would play through that TV.
Through the speaker on that TV? Okay. Yeah. Well, and we also have the RAW speaker option. Let's see. All right, keep playing it, and I'm going to see if this volume adjustment does anything. Do your job. I didn't do anything. Is there? Because that volume's too low.
You just surprised to, I studied the whole bunch of government. Yeah, so I got you, Virginia. You have the right to mix out. Anything you say will be used in court as evidence against you. You're entitled to have a lawyer now, and have he or she present now at any time of the question. If you're not for the lawyer, one will be appointed for you without cost. And he or she may be present at all times during questioning. You can decide at any time to exercise these rights and not answer questions.
Because I can control the volume.
You understand these rights? You wish to talk right now with our lawyer. Yeah. Okay. So let's get some quick things up here. Britton, Marquez, Dennis, you just stay in Elwood? No. That 3750, that's where mom's there, right? No. Okay, you stay with mom? No. Okay, you just use that address? Okay, gotcha. Is that one of your business addresses?
That's right.
That's okay, okay, yeah.
You can pause it. I'll adjust it a little bit for them. They can say, I think if it is a little less loud, it is easier to hear. We'll see what happens. All right. Anything from the state before we bring the jury in? Mr. Bass? Anything before we bring the jury in? Okay, let's bring them in, please. And you got it. Great.
So they can do those so everything you have to do liberation, they don't start. You say Tuesday this happened, it's wrong, and on Thursday this happened. They're going to make it that happens. They're going to get you on. Okay, that opens up a lot. It has not come in. Right now, it's down about a lot of stuff. And that hurts you. You have to find them close up.
All right, jury.
Mr. President of the County Court.
Thank you, Deputy Gordon. Everyone else, please be seated. Good morning. Good morning, everyone else. Okay. You all have asked to watch and listen to the interview between Detective Stansel and Mr. Dennis again, which you can. That has to be out here. That's not something that can be back in the jury room. I discussed it with the parties, and I think the issue last time was almost too loud, which is rarely the problem in court, is I can't see, I can't hear. So we've done a couple things. We turned off one speaker that helps Ms. Rivers hear soft-spoken people. No one was soft-spoken in the interview. And I have a little volume control here that is a little bulky, but we're going to play it again. We may get partway through and I'll pause it to say, is this a good volume? And then I can make it louder or less loud. I can make it really loud where you can't hear anything. We got it all the way down where you couldn't hear anything. And so maybe we'll find the baby bear spot in the middle that's just right. We'll play it. And if you need to hear it again, we'll play it again. What you can't do is talk amongst yourselves while it's playing out here. Feel free to take notes, but you all don't interact while we're here in court. You go back to the jury room and then have the discussion you want about what we're going to listen to. All right, Mr. Abad, if you'd give it a try, please.
And it was all right.
Sorry. Catch my phone.
All right. Man, you don't know, I don't even talk to the police.
I mean, so this is why I give you credit, right?
Yeah.
Clearly, you got a story to tell, right? And I get it. And my whole thing is, I want to make sure that you tell your story. But I gotta go through a few things, okay? So you're free to go. But I still gotta write out you, okay? You just gotta understand it. So you see the show, bro.
Bro, I've studied law, so I know it. I've studied the whole judicial branch. I studied the whole branch of government.
Yeah, so I got you. Send you out. You have the right to commence out. Anything you say will be used in court as evidence against you. You're entitled to have a lawyer now and have he or she present now or at any time of the question. If you cannot afford a lawyer, one will be appointed for you without cost. And he or she may be present at all times during question. You can decide at any time to exercise these rights and not answer questions, any questions or make mistakes. You understand these rights? You wish to talk to right now with our lawyer.
Yeah.
Okay. So let's get some quick things up here. Britton, Marquez, Dennis, you just stand Elwood?
Yeah.
That 3750, that's where mom's there, right? Okay, you stay with your mom?
No.
Okay, you just use that address? Okay, gotcha. Is that one of your business addresses?
That's right.
That's okay, yeah. That's not fake business address.
Okay, so let me put you, I don't know how you know, I don't know if you know.
Yeah.
But what I'm saying, yeah, I am the executive buddy of strong man.
Yeah, I saw the letter. You got a lot, you and your dad got a lot going on. And even with the breeding, those aren't low tier dogs.
Exactly.
That's a purebred friendship.
Exactly. Bro.
Like those are hard to come by.
Exactly.
And I don't think you with the purebred you have to nose it because I know they have nasal issues and shit. So for you, y'all, the dogs well kept. I know your dad's got the lawnmower thing. I got hustles, so I can manage. So with that being said, bro, hey man, walk them through what happened yesterday.
Alright, do what I bro. I come out my door to go to work.
Right.
This nigga get my truck.
What was your truck part?
In the driveway.
Okay.
So boom, I'm coming out, I'm finna go to work.
Yeah.
So as I come out the door, I guess the nigga like, oh shit, you feel me? So he trying to get out the truck, but the nigga got a knife. Okay. So he trying to get out the truck, you know me, if you don't did my history, bro, I done did 10 years in you know what I'm saying? So I don't know, then he want me on. Boom, so you in my yard and my shit, I got the right to get on your ass.
So you have anything on you?
I ain't got nothing. I'm coming out to go to work. You bitch. Shit, so boom. So boom, the nigga swing the knife at me, bro. Swing like, you do one of them.
Yeah.
And when I grab him, boom, he get back up, but when I grab him, he drop the knife.
Okay.
So that was it right there.
Okay.
So boom, now I gonna fight. Fuck all that. You feel me? So I let him get back up. Nigga, give me your money. You gonna break my shit. You feel me? Give me your money. So boom, I just he hit me in the look. Yeah, so he hit me in the look. Boom. We got to fight, long story short, bro. I beat him up. I told him, I don't beat him up. I told my little brother to call the police. You know what I'm saying? So my little brother called the police. I'm got him on the ground like shit. I'm beating him up. You feel me? So the police asking all the question, and little bro, he tell them, so shit, when I ain't calm, long story short, bro, I ain't got no wind to keep on trying to hold them and beat no man up to wait for no police to get here. So we touching, you know, cause I told him shit, bro, I'm trying to save you, bro. That nigga murdered, bro. Just tell you the truth. So boom, I'm trying to save you. So boom, I got him like this, so I'm getting tired, bro, you feel me? So we scuffing. I'm trying to hold and wait for the police, trying to do right. So goddamn, he got to do. He took out. When he took out, I get my try to go to work. Shit, it was all favorite.
All right, what time do you think on that?
Like 5. I get ready to go to work like 5:30, 6 o'clock. You know what I'm saying?
And yes, so I'm clear. That's all I have.
That's all I have.
All right, keep it.
All right.
We like 50% of the way there. That's what I said. See, when they gas on the street, gas station got a camera that points right at your house.
Okay. It don't point at
I know it does because I got a video for you.
Okay.
So, I ask you got all that. Because what I need you to understand is this is your opportunity to tell the truth, to tell your side. Okay? And if you aren't like really forthcoming with me, bro, I gotta fill in the blanks with not speculation, but facts based on video evidence. And I'd rather you tell me what happened than that what happened with the video. That makes a lot of sense. So I can tell you is he did not run away. He didn't run out. I can tell you that right now. He did not run out. How did he get done? Just keep it on, bro. How you get done? Huh? Who took it? It was you and us. There's 2 people carrying him. It's on video.
Well, I don't know, bro.
But you took it. So you say you took it.
No.
So how you get down there?
Lord,
You want a lawyer?
this part,
So,
All right, ladies and gentlemen, was that more audible than last time? Yes?
Yes.
We need to hear it again, or you want to go discuss and then let us know?
We're good.
Go discuss? Okay. Again, it's available for re-listening if that's what you need. You've got the other digital evidence back there, and apparently one of you is a tech guru because you figured out how to do the Zooming. So thank you for that. When you are ready to break for lunch, just let Deputy Gordon know, because you all have to break when there's a break. Forget about lunch. If one of you in 10 minutes says, I need a 5-minute break, everyone is taking a 5-minute break because all 12 of you need to be engaged with the discussions. But lunch will happen when you want lunch to happen. We just need to know so the lawyers can be at ease knowing that, oh, they're not going to have a question or a verdict or something, and they can take their lunch break as well. Okay? Thank you for your focus.
All right, do it.
So I gave Ms. Rivers yesterday at the end of the day, all 50 note cards that the jurors had submitted as potential questions of witnesses. Those will be made part of the record as a court's exhibit collectively. It includes questions that were asked and not asked. It was every single submission from the jury. I will later make part of the record as another court's exhibit these 2 note cards, which is, can someone show us how to Zoom? Can we watch the interview again? And any other questions we end up getting from the jury, those will be made part of the record at the end of deliberations. Mr. Rao, anything else from the state at this point? Mr. Bass from the defense? No. All right, Mr. Dennis, we'll bring you back out here whenever there's another question or something else from the jury.